one for leave to file without certified copy. The appeal. Memorandum of appeal.
When was the order passed?
My lord, order was passed on 26th of June, my lord. We immediately applied, but the file has not yet been received by the member section. We have not got the we could not obtain the certified copy.
Did you apply?
Yes, yes, my lord. I applied immediately thereafter.
Second order, 14th of June.
What is the urgency?
My lord, urgency is this, my lord, and my lord, an order was first for ossification test, my lord. On the basis that the age assessment done by us, my lord, it has two views, two outputs.
Then why the file has not come down? The matter has been disposed of.
No, matter is not yet disposed of.
It was an interim order.
Yes, my lord. I filed a recalling application that was refused, my lord. Rejected.
Your Lordship,
Grateful,
may
ma'am.
I have your kind leave to mention a matter for extension of interim order. The interim order is expiring today, Your Lordship. On 14th of June, an order was passed, Your Lordship, by which the EZCC's director is operating, Your Lordship. I am for Union of India, Your Lordship.
Who is your other side?
I have served, Victor Chatterjee is my other side. I have served, Your Lordship, there are three connected matters.
Extension.
I have already filed application as well, Your
Uh,
Lordship.
I am for the EZCC in this matter. Ma'am. In this matter, today is the last date of interim order. Ma'am. So may I be permitted to file one,
It will appear tomorrow. If the file comes, it will appear.
my lord? Ma'am.
Sincerely
May I
obliged,
be,
Your Lordship.
may I be, my lord? Just a moment. Let the front row be over. Let the front row be over.
Yes.
Yes.
There is a typographical error in the case number before the tribunal. Instead of OA number 189,
What order? Ours to be mentioned. Yes.
Thursday, my lord.
Huh?
Let it be on Thursday. Today and tomorrow I have some difficulties.
Thursday, the other order. Yes.
Inclusion in the list, my lord, is the group 6 appeal. It was running in the list.
Sir, please wait. We let the combined list come. We have accepted many matters for that. Let the combined list come. Please wait for some time. Unnecessarily adding matters won't help. Please remind us after this.
And I am mentioning group 6 application in earlier occasion matter was heard and appeared petition has been given to appear under the application on 20th July 2023. There is a-
Application was hard.
Yes, application.
Then what happened?
And direction has been given to inquiry by the CID and file a report on 20th.
20
20th July.
before us.
Before.
It was our order.
No, previous bench order.
Wait for some time. Let
Because
us.
the petitioner applicant affected non-giving.
How he will be affected? The report has been called upon to be filed before High Court.
The report has been filed by the CID and matter will appear on 20th July 2022. Direction has been given. I annex the copy of the order.
কি করবে বলো তো?
Great.
To mention, one matter, your lordship, is an assigned matter. Your lordship, interim order, your lordship, is expiring today. Your lordship, kindly remember Mr. Jishnu Chaudhary, your lordship, was appearing in court number 32, your lordship, make.
Which one? Which one?
Your lordship, is not in the list, it's an assigned matter, your lordship.
It is not in the list.
No. Mr. Chaudhary, your lordship, making a submission, your lordship, and suit, your lordship, order 7, rule 11, your lordship, dismissed.
The assigned matter এ ঢুকিয়ে দাও। Yes.
Even your lordship.
On the list, on the list.
Yes.
My lord, may I crave your lordship's kind leave, my lord?
Yes.
Subject to lordship's kind indulgence, my lord. This matter was running in the list, my lord, lastly called on 12th instant, my lord.
Our list.
My lord. And it was directed to appear on 17th. Your lordship may take it up any day, my lord. It was directed to appear on 17th, last called on 12th instant, my lord.
যেগুলো এর মধ্যে রিটার্নেবল ছিল। Listen, it will appear as assigned under the assigned here. You have to bring your other side and mention.
My lord, may I hand over the slip, my lord?
And you know,
New motion, my lord, tribunal application.
My lord, I am paying for inclusion under the heading extension of interim order, my lord. The interim order is expiring on 3rd, that is on Thursday. If your lordship kindly includes this
It's
matter.
your other side.
My lord, other side, I have served notice, my lord.
That
Parnala.
assigned matter, municipal.
No. This is not an assigned. Group 6 mandamus appeals. My lord, there are 3 appeals, 4 appeals, my lord, all arising out of the same order, my lord, where we are enjoying an order of my lord, stay of the impugned order passed by the honorable trial judge, by which, my lord, the services of
Expiring on 3rd,
Third.
when it has been made returnable.
my lord, it has not been made returnable as such in view of the fact that your lordship was not available on 6th July, my lord. The matter with the interim order was extended by the honorable division bench presided over by the honorable justice Somen Sen.
His lordship has extended.
Extended till, my lord, 4 weeks from that day, that is expiring on 3rd.
How can it be? Because I was not there for 2 weeks.
No, my lord, it is on 6th July, your lordship was not sitting. And therefore, the determination of your lordship was, my lord, given to the honorable justice Somen Sen, my lord. It is recorded in the. If your lordship kindly includes this tomorrow, my lord.
Wait, sir. Let us outside.
My
the
lord,
list.
may I have your lordship's leave to mention in regard to item number 170 of the lordship's list?
Oh, just wait. Any
Or
outside list?
listing as a central tribunal matter, my lord.
Hand over the outside list. matter. Wait. Any addition in the list, please hand over.
Inclusion.
Addition in the-
I don't know. এই আমার কাছে দাও, আমি দিচ্ছি।
এই যে নিয়ে নিন এটা।
My lord, regarding
I need to mention a matter, my lord, this is for extension of interim order.
When is it expiring?
My lord, this expired on 26th this month, my lord. 26th of this month, that is July, my lord, 26th July. When this bench was not available.
Come up with an application now,
My
Mr.
lord, this, my lord, this, in fact.
Then you serve
Milord,
your other side.
My other side.
no, my lord, I am opposing last occasion he
It
took.
has expired, Mr. Drolia. You take appropriate
My lord,
steps.
Here, my lord, here, I tried to mention matter before justice was not, then I was told that we go before the, my lord, appropriate bench.
Yes,
Yes,
it was within the time. Then it was within the time.
within time I mentioned.
So you come and mention, come with a short application.
My lord, kindly have a look, not this order.
কি বলেছে?
Original order is 15th May 2023 by Justice Tandon. And my other side is here. my lord.
By suppression of material fact, he got the order.
Wait. It was extended for 4 weeks.
4 weeks.
Then what were you doing thereafter?
My lord, then 26th is expiring. It's
Very good.
expiring. I mentioned on 24th. I mentioned before court number 5. For
Right,
extension.
then.
I was told you go before the appropriate bench.
So very good. Now you have mentioned the interim order has expired. Come with a short
There was no
application.
bench available, my lord, at that. On that day, my lord, I tried to mention, I did not get that, my lord, that.
Sir, I don't understand. What is the interim order?
My lord, interim order is stay. Interim order is stay.
Interim order of
Interim order of stay of the central administrative order. It's a defense matter. Defense of India. My other side is here. my
My
lord.
lord, without any notice, he is mentioning, but he also mentioned.
Please
yeah.
come back tomorrow. Yes. As requested by you, it was done. Now you are opposite. The order runs as requested by Mr. Das. Post the matter 3 weeks.
But in the last
Now you
occasion,
are
he
saying
has
don't-
mentioned.
Uh-huh.
Last occasion, he has mentioned before Justice Devanshu Bata, he did not serve any notice to me.
Give a notice to him and come back.
Not may I have your lordship. My lord, I have some personal.
Wait.
Bro.
Yes.
That is the assigned matter, your lordship. Order is expiring today. Should I give notice, your lordship? and
Which one?
That assigned matter, your lordship, first appeal assigned matter.
So we have said it will appear tomorrow.
I'll give notice again.
Yes. Or any outside list mentioning?
Yes.
Extension of interim order, my lord, interim order expiring today, my lord.
Outside.
It's my lord's order, my lord. It's Pirannagar Municipal Corporation.
Any outside list?
My lord, first appeal, part had first appeal, my lord.
First পাঠার নিয়ে নাও তাহলে
Application.
শোনো চূড়ান্ত এবার না মেনশনিং
But in the list, but I have some submission, my lord, today and
wait Mr. Das. Yes.
In regard to item number 100
are being jeopardized, my lord. The only simple question of law involved, my lord, whether
Please do not.
my lord, kindly.
Yes.
Today and tomorrow, I have some gap.
Don't have any junior.
I have junior, my lord.
Trust faith on your junior. Yes.
My lord, in that case, my lord, I shall take my chance in the next week, my lord.
I was also praying for upgradation.
Upgradation in assigned matter is 25.
We will segregate matters. We will take up on specific dates tribunal application appeal. So don't worry. Let the wait for this week. Let the combined list come. Yes, call the list.
My lord, may I be permitted to mention, my lord?
I'm mentioning for releasing, my lord, because one my lord appear in this matter. That's why.
Who is your other side?
Let it be fixed any date. I will serve a notice to the other side.
60
and 61
60 and 61
on this list, today's list.
to be mentioned.
Next week or any date, I will.
But give a notice to your other
Yes,
side.
yes,
Yes.
My lord, may I be permitted to mention, my lord, today's list item number 71, my lord. My lord, gentlemen, the petitioner was dismissed from service, my lord, since 2008, and his dismissal was confirmed on 2012 by the CAT bench, your lordship. He has
No upgradation, sir.
my lord, he is suffering from aging ailments, your lordship. He is
Just
now
wait-
a senior
Wait for
citizen. your
this week. Let us see. Yes.
Lordship, one humble submission, Lordship, for upgradation only, under the heading assigned matters, Lordship, these are the city court matters under order 41 rule 11. Determination has been subsequently given to courtroom number 13, Lordship. So it's for upgradation or as your Lordship desire if it is to be released or.
13 এ কি করেছে?
Lordship, Honorable Justice Rajshekhar Mantha and.
কি চাইছে? What you are
Lordship,
wanting?
these are the matters which is.
What you are wanting?
Lordship, either upgradation or if your Lordship desires it to be released, then released. No,
How
not.
can it be released when it has been assigned to us unless we have any personal problem? It will appear under assigned hearing. Assigned hearing at the
Lordship, then for upgradation, Lordship, you have, your Lordship has already,
Sorry, madam, let it appear, then mention. Yes.
these are appearing under assigned matters.
Then why you are mentioning?
For upgradation.
So upgradation, we will be taking up assigned matter. Which is your matter?
221 to 226.
Where from the assigned matter starts? Yes.
My lord, in this matter, I am appearing on behalf of the state, my lord. My lord, on last occasion also the petitioner not appeared in this matter. My lord, in this matter, last occasion on 19th June, when the matter was appear before your lordship, I assured before your lordship that a team will be formed and it will go to the native place of the missing boy at Bihar, Gaya district. The team went there and interrogated the local people as well as the villagers, but no fruitful result found. They said they never seen him in their area after his missing, my lord.
Where is your report?
My lord, kindly. I am submitting the report. Bollam to.
Okay.
And my lord, the Deputy Inspector General of Police, CID, personally took the matter, my lord. He sent the requisition to the Director General of BSF and circulated it all over the India in all outposts, my lord. Kindly see the report. Since long the matter is pending, my lord. My lord, this is pertinent to mention.
রিপোর্টটা কি নিয়ে নেবো?
Yeah, it would be taken on.
No one appears on behalf, no one appears on behalf of the petitioner and no accommodation has been sought for. Though Mr. Chatterjee, learned advocate, appearing for the state is present. Stop. A report as produced by Mr. Chatterjee is taken on record. Because in view thereof, writ petition is dismissed for default, however, without order as prescribed. Dismissed for default.
I don't know. Well, the report may be kept on record.
Yes.
No, we will keep it at other places.
No, I beg to appear on the petitioner, my lord. In this matter, my lord, petitioner's daughter was missing since.
You are appearing.
My lord, he is appearing, I am appearing with him, my lord.
Yes.
Since, my lord, 25th of July 2022, petitioner's daughter was missing. Several times your lordship directed to do some positive steps so that petitioner could get about his daughters. One of the principal accused even not arrested, my lord. Lastly, on 19th of June 2023, your lordship directed.
Your daughter,
Yes, my lord, my lord.
then she went missing from when?
25th of July 2022.
22 years old.
Yes.
My lord,
Went to Bangalore for training.
my lord, in this matter, some time is required. Last time, it was submitted before your lordship. The mobile phone of the mother of the victim was seized and it was sent to the forensic laboratory for test, my lord. But till date, the result is not come, my lord. It
Why?
yet to be came.
Why we directed on
My lord, several time intimation was sent to the forensic department, my lord, including the superintendent of police, my lord. Kindly adjourn the matter for 1 week at least.
2 weeks?
Great.
2 weeks. Mr. Chatterjee, we will call your SP in personally in court. If he doesn't respond, we will call all of them in court.
My lord, give me 1 week time. I will.
Better take appropriate steps.
My lord.
I am for the respondent number 6, man. I am for petitioner, lordship.
Petition. My lord,
I am the respondent.
I am
number
appearing
6.
on behalf of the state.
Who is for the petition?
I am for petitioner, lordship.
This is my lord,
Ask
very
for-
unfortunate case. This is not. This is a case of
Drowning.
drowning, my lord.
We are also very shocked, my lord, but
My lord, the son of the petitioner went to river Ganga for taking bath, and at that time he was floated away in the river Ganges, my lord. And several persons were there. They have made statement, my lord. Detailed inquiry report is filing. I am filing the report today, my lord.
you put it a copy.
My lord, leave me. My lord, leave me. ফাইনাল রিপোর্ট করে দিয়েছে এই পিটিশনটা দেখো চিনা ফোন কেসটা কি এক গাদা আমি একটু মাইনাস দেবো এটার কপি দেবো কপি দেখতে পাচ্ছি
কি করবে বলো?
My lord, kindly see the detailed inquiry report, my lord. The petitioner have also the knowledge of drowning, my lord.
Now they subsequently lodged the complaint against that Hon'ble.
My lord.
Against that, my lord,
Sorry,
first,
respondent
first-
six.
my lord, may I be permitted, my lord? On that day, after knowing the facts, police immediately went to the place. One general diary was lodged. Thereafter, disaster management team was called for. They immediately plunged in the water, but could not find the body also. Due to heavy current, heavy tide of river Ganga at that point of time, my lord. Thereafter, next day, the father made a complaint, which was also treated as general diary, my lord. Thereafter, some persons were there in the ghat of river Ganga. They have seen the incident. They have stated before the police that they have cautioned them not to go into the water of river, my lord. But still, he went there. That boy, that friend, who was taking photograph, my lord. That missing boy told his friend to take photograph when he is taking bath, and especially when he is driving, my lord. First time he drove, he returned from inside the river. Thereafter, second time when he drove,
All
he
right.
could
When
not
was the
survive.
incident? When was the incident?
4th April, my
4th
lord.
April
2022.
2022.
22, my lord.
Then when did they turn back and complain against the boy?
My lord, one unnatural death case was started on that day.
No, so far as we remember that the Hon'ble Das,
Yes.
now they are alleging against Hon'ble.
No, my lord, not. My lord,
Yes,
kindly
yes.
see the investigation report first, page by page. I'm submitting.
My
before the
allegation
lord.
Kindly, my lord,
Kindly
ask my
give-
learned friend to solve a copy, my lord.
আমি দিচ্ছি একটু পরে দাঁড়াও। It will be clear, my lord. My lord, kindly see.
After 1 year, UD case started. Upon
My lord-
direction by my lordship.
My lord, kindly see page 1, 2, 3, 4, 5, and 6. This is a pure case of drowning. Habeas corpus is not. My lord, kindly see page number 1, 2, 3, 4, 5, and 6. The photographs. And my lord, kindly see the eyewitness statement also, my lord.
Final report submit করে দিন। Final report of education final report submit করেছে। First paragraph. There is no iota of doubt that the missing subject, namely Nirmal Mukherjee, has died in an unfortunate incident that occurred after. The most saddening part is that the body of the said missing subject is still missing. I am submitting final.
My lord, kindly see page number 43 and 44. Those are vital evidence, my lord.
No, when the complaint, first there was a missing diary.
First, there was a missing diary.
So there was no complaint was treated as FIR.
No FIR has been lodged, my lord.
Acha, then you started a UD case.
UD case.
When did you start that?
UD case has been started, my lord.
23.
1st April 2023.
2003.
After
And the
direction,
UD case was
my lordship. Then it started.
final report of record UD case has sent to the learned magistrate under section 174 of the CRPC. Kindly see page number 29. 29. My lord, it was within the knowledge of the petitioner that her.
What was his age?
Son,
What was his age?
he is
Boy's
major,
age?
major.
23 is engineering.
He is a student of engineering at.
Now, unnatural death case final report.
Yes,
filed.
my lord. Yes, my lord. By page 29.
Sir, what?
My lord, one thing I pray, my lord. Incident took place on 4th April 2022. Thereafter, my lord, I returned several written complaint additional commissioner, etc. They are lastly I filed this writ petition. My lord was pleased to 23rd, 27 March 2003 direct the police to start the UD case. After 1 year of the incident, police start the UD case. Not only that, respondent number 6 is a political son of the political leader. We have no faith upon the what practice. My unfortunate father being unfortunate, I am only pray, my lord, kindly this can hand over the CID, my lord.
My lord, all
This is my
steps has
fear,
been
my lord.
taken.
It is an unfortunate
Yes,
incident. It is an unfortunate incident, but the person has gone missing. We still kept the matter so that the police authorities can keep vigil over the matter and come up with any incriminating material, because they were thinking as to the private respondents had any role to play. So when that has been done, now final report has been filed. You are free to take Naraji petition there in the final report.
Or Nalaji petition.
But we have kept it since it was an unfortunate. Further
My lord,
elongating the matter.
After
won't.
1 year, my lord, after direction by my lord, then they start the UD case, my lord. Not only that,
So what did you do within that 1 year? You were also no. You, if it had been somebody has shown your son, the natural consequence is that immediately I will rush to various quarters. You also did not, because you knew that.
7 written complaint to the joint commissioner of police. My lord,
Petitioner has the knowledge that his son was died.
Annexer P1, P2, P3, P4. Lastly, I filed this writ petition, my lord. And my lord, 27 March, my lord was pleased to direct the police to UD case.
Yes, yes.
The writ petition has been prepared primarily for the following reliefs.
But can we get a copy, my lord?
Fact as unfold in the writ
I am
petition
the petition, kindly direct
to
me
complain
with a copy of-
Yes, we have.
is that the petitioner's sons every Nirmallo Mukhopadhyay, in short, Nirmallo, aged about 23 years, went to have a bath the Ganga on 4th April
2020.
But he was missing, and consequently on the very next day, one missing diary, file number 344 dated 5th April 2023 was lost. And on 9th April 2022 and on 6th April 2022. The writ petitioner make a complaint before the Deputy Commissioner of Police, North Zone Barakpur, Kolkata, stating that during interrogation, the friends of his missing son made some contradictory statement, and accordingly, a thorough inquiry is required to be done to unearth the truth. The petitioner, এখানে আবার একটা 2 তারিখ একটা লেডি পুলিশ অফিসার কি মিস কল দিয়ে বলেছিল
On a 6 May, I lodged a written complaint against the respondent 6 May 2022. Annexer P1, page 22.
ছবি তুলেছি inquiry. further submits that after almost 1 year, one unnatural death case was started only on 1st April 2023, and the petitioners, by making complaints to various authorities, have ventilated his grievances and requested to take appropriate steps to find his missing sons, but no fruitful steps has been, no effective step has been taken. Stop. Aggrieved thereby, the petitioner has been constrained, the petitioner has been constrained to approach this court by taking out this instant petition. ঠিক আছে?
In the meets there of investigation in the UP case.
Stop. Mr. Chatterjee, learned advocate, appearing for the state, submits that the petitioner's sons went to have a bath in the Ganga, and when he was driving in the Ganga, then due to strong current, he drowned, and unfortunate fact is that his body could not be traced. Although disaster management group was employed to find out his body, he submits that the boy was drowned and there is no foul play in the matter, and he submits that the police authority, after
completion of
investigation, has submitted final report
in the
unnatural death case. The learned advocate peruse the CD and other materials on record. From the record, it is appearing that the petitioners, that the investigating agency has, after completion of investigation, has submitted charge sheet, has submitted final report in respect of the UD case, and
you do not find any material in
and the concerned investigation agency has arrived at a conclusion that there was no iota of doubt that the son of the petitioner's son drowned in the Ganga, and till the date his body could not be traced out. Considering such facts and circumstances, we didn't find any material to infer that the petitioner's son was illegally detained by any person or authority. Stop. In view thereof, no interference is required to be called for in the writ petition. Consequently, the same is disposed of, however, without any order as to the court.
Nothing in this order will prevent the petitioner from
Nothing in this order will prevent the petitioner from taking appropriate steps before the appropriate forum.
Naraji, file kore do.
I'll give the direction to give me a copy, my lord. One
Copy may kindly be given, my lord, so that
I am
copy may kindly be given, so that we can go through the copy, my lord.
Yes, call the next.
Report of copy change.
কপি তুলে দিই আমরা রিপোর্টে আছি
I'll oblige to you.
Yes, for
I'm for the petitioner is the unfortunate mother, my lord. My lord, his her son, my lord, Somir Mondol, he was selected as a armed
What is your age? Boy's age?
Boys is my lord, 18 years, my lord.
কি হলো?
My lord, in this matter, Mr. Ahmed is appearing, my lord.
Who?
Mr. Sabir Ahmed.
Yes.
So he has not come today, my lord. My learned brother is saying for taking an adjournment.
What is the report? We called for a report.
I am submitting the report.
দেখি report.
And also from the এটা কি? এবার বল কি হয়েছে?
But DNA test was
Yes, my
conducted.
lord. Unidentified body was found, and the body parts was sent for DNA profiling, my lord. For the my lord, I am praying for some time for the report, for obtaining the report.
It has been sent for DNA profiling.
Yes, my lord, it was sent. My lord, kindly see, it was report. In report.
Sir, I'm
2
sorry,
weeks.
my lord.
Yes, এটা ওনাকে দিয়ে দাও. Let him come back with the report.
Sir, may I get the
Report
Let him, he will file.
Sir, I'm
Take
sorry.
back your report. Take back your report. Come with a revised report on the returnable. What had been the outcome? ওদের determination. লিখিত আছে। Yes, next.
Sir, next, my lord, 2 weeks.
2 weeks.
Lord, in item number 5, my lord, I beg to appear on behalf of the petitioner. Now, my lord, before your lordship takes up the pain to take up the matter, my lord, Lord, I congratulate my learned friend, my lord, as also the police authorities, my lord, they have recovered the girl from Bihar. And my lord, they have already taken the girl in a home. A proceeding has been initiated under the POCSO Act. And my lord, that is all from my part. My lord can pass necessary.
Mr. Mukhopadhyay, learned advocate appearing for the petitioner submits that the victim girl has already been recovered.
Yes, Lord.
Stop. Miss Moulik, learned advocate appearing for the state.
Wait, Lordship, this is the report. The girl,
Also,
Yeah, the one.
the girl is in the home. ठीक है.
Mr. Mukhopadhyay, learned advocate appearing for the petitioner submits that the victim girl has already been recovered. Stop. In view thereof, no further order is required to be passed in the present petition, and the same is accordingly disposed of. Stop. Miss Moulik, let the report as placed by Miss Moulik, learned advocate appearing for the state be kept on record.
Grateful, Lordship.
I am for the state.
For the petition. I am for the private respondent, Your Lordship.
In this matter, 164 statement of the lady was taken, my lord. And he stated in his statement that he is willingly residing with his parents, my lord. Kindly see the report. My lord, the report. ফটোকপি my lord এর লিভ ছাড়া দেয়া যাবে না।
ওটা কি? Where is the 164?
Lordship, last page. Lordship,
After-
second last
Parveen.
page, second last page.
Afroza Parveen.
Yes.
Yes, yes.
এগুলো পেজিনেশনও করে না। এফআইআরটা লজ হয়েছে দেখে রাখি।
বন্ধুত্বের সম্পর্ক। বিবেকানন্দ ঝাকে 6-7 মাস আগে থেকে আমাদের বন্ধুত্বের সম্পর্ক ছিল। কি বলে প্লেট কিনতে গেছিলাম মেন গেটের ওখানে ছোট ভাই দাঁড়িয়েছিল মানে ওই বিবেকানন্দ।
এটা 6
বাড়িতে যাওয়ার পর
কপি তো দেয়া যাবে না।
এরা কি আমার
my lord এর থেকে চাপ।
বিবেকানন্দ
নিজের ইচ্ছা আছে তো। ভালো লোক নয়।
বিদ্যানন্দ বিবেকানন্দ
Vivekananda. Oh, Vivekananda.
হ্যাঁ এইটা দেখিয়ে দাও।
মা বাবাকে ছাড়া যেতে পারবে না। পার্কে যাওয়া নাম করে কালীঘাটে গিয়ে আর মন্দিরে আর একা চলে আমি তার সাথে কি বললো তারপর ওর বাড়িতে আমি চলে আসি আর
এটা কেন my lord বুঝতে পারছেন না, আমি বলে দিচ্ছি কবে দিল দেখো। After lodging. My lord, in this case,
just on
You have a copy of the report.
my lord, I am giving a copy, my lord. Not only that, during pendency of this petition, my lord, this petitioner went to the house of that lady with some unknown persons and antisocials. For that reason, one complaint has been lodged and FIR was also started on 15th July 2023 after your lordship's order. This is the conduct of the petitioner, my lord. Kindly see the FIR. It was also annexed. একটাই কপি আছে। পিটিশনের তো করে দিচ্ছি তো।
The present writ petition has been referred
আবার জিজ্ঞেস করলো এতটা দেখি।
primarily praying for the following relief বলে এটা কোট করে দিই Mr. Das Landed advocate appearing for the petitioner submits That the petitioner is a student pursuing a degree in bioscience from Vijaygarh Jyotish Rai College, affiliated under University of Calicut. While in course of his while studying there, he met with one Afroza party, aged about 22 years. Stop. Aged about 22 years, and
ও থাকতে চায় না বলেছে তাই তো
he fell in love with Afroza. And he subsequently fell in love with Afroza. Stop. Initially, the parents of Afroza were not aware of this love relationship, but upon coming to learn about such relationship, they strongly protested against it. Finally, on 27th April 2023, Afroza left her parents' house and came over to the petitioner's parental house and expressed her desire to reside with him. Stop. When they were residing together at subsequently they were residing together at the petitioner's parental house. But on 29th April 2023, the respondent number 4, along with antisocial elements,
Page 97.
entered the petitioner's residence and forcibly took away Afroza. Right? Video. Took away Afroza. Stop. আবার কি করো 4th May আবার কি করো Mr. Das submits. Mr. Das further submits. এপ্রিলে নিয়ে গেল আবার 29th এপ্রিলে নিয়ে গেল আবার বিয়ে করে ফেললো 4 তারিখ। Then if she was taken away on 29th April, how did you get her again to go to Kalighat on 4th May?
My lord, that is what is now stated, but she was residing with the petitioner at that
She
time.
was residing with the on 29th April. Some miscreants entered your house and took her away.
Your lordship, she recorded her statement.
No, kindly come to page, paragraph 9.
Paragraph 9.
Of the petition, your lordship.
Sorry. So that you now.
Yes, my lord, they arrived.
They came and took away. Again, how did you marry her on 4th?
My lord, but our version is they did not take away on that day. In front of everybody, we have attached a CD. She gave a statement she wants to reside with the petitioner. That we have annexed as the CD. This was video recorded. She stayed back. Then on 4th April, she married. After that, she left. That is our 4th May. After that, she left, my lord, on
Arrived to take, but could not take.
June 15. On 29, she did not go back.
Attempted to take.
My lord, I can show the video recording on 29.
Attempted to take.
কি হলো on 29th April এটা লিখেছো and attempted to take away Afroza, but in vain. Stop. Afroza stayed in the petitioner's parental house, and on 4th May 2023, he married Afroza in accordance with Hindu rites and ceremonies. Such marriage was also consummated, and they were living as husband and wife. বলেছেন pregnant?
That is what against my 164 statement টা তো নেওয়া হয়েছে পরে FIR টা লঞ্চ করা
চলে আসে। তখন বলেছে,
বলছে বিয়ে but in 164 she admitted marriage took place.
Oh my lord, I am disputing the marriage, my lord.
She says powder was put on her head.
Inter-religion
আর এটাও বলে যে মা বাবা জোর করে আমাকে আটকে রেখেছে
without registration of special marriage act you cannot say.
Stated that in
আর আমার পেটে নাকি এটা আছে। So when did he last hear the matter? 14 July.
14 July.
When did this incident again happen?
19th.
16th.
On 19th, my lord. The FIR আমাকে রেকর্ড
রিডিং
দাও আমি দেখছি। My lord, on 15th July 2023.
as per 164 it is 16 July.
Case was started under section 363, 511, 506 and 34 of the Indian Penal Code, my lord. এটা তাহলে
their marriage was consummated.
15 বাংলায় বাংলার পাঁচ এটা
Stop.
তুমি এটা নিও না পরে দিচ্ছি।
Subsequently, on 15th of June 2023, 15th of June 2023, Afroza's parents subsequently on 15 June 2023, Afroza was allowed to meet with her parents, went to meet with her parents, and thereafter she was physically prevented from returning to her matrimonial house. Stop. Stating such facts, the petitioner lodged a complaint on 21st of June 2023 before the officer in charge, Narendrapur Police Station. But subsequently, no steps were taken. Aggrieved thereby, the petitioner has approached this court. Mr. Das submits that the petitioner entered into a matrimonial relationship with Afroza. Both of them are adult, and as such, the petitioner should be allowed to reside. And as such, the Afroza should be allowed to reside with the petitioner and to lead matrimonial life. Stop. The parents of Afroza are standing in the way and are standing in the way and are preventing the petitioner to lead normal matrimonial life with Afroza. Stop. Per contra, Mr. Chatterjee, learned advocate appearing for by an earlier order dated 14th July 2023, this court directed the respondent number 3 to file a report as regards the steps taken on the basis of the complaint lodged by the petitioner. Stop. Mr. Chatterjee, learned advocate appearing for the state submits that even after such order was passed by this court, the petitioner, along with antisocial elements went to Afroza's house on 16th July 2023 and attempted to that fact was diarized. 16 July fact was diarized.
Yes, my lord.
Where is
FIR has been lodged.
Where is that?
My lord, kindly see in the report, first annexure. Narendrapur PS case number 651 of 23, my lord.
Who lodged the complaint?
Afroza Parvin herself lodged the complaint.
The petitioner along with went to Afroza's house and on 16 and attempted to forcibly and went to Afroza's house and attempted to forcibly
My lord, one humble submission.
and attempted to what?
My lord, in this aspect, the petitioner claiming himself as the husband of the lady. But my lord, I am disputing the facts, my lord. In the complaint, that lady said she went there by force, and your lordship is aware.
Investigation is completing.
Investigation is going on.
That investigation is going on.
Yes,
His
my lord.
complaint has been registered.
Yes, my lord.
And the subsequent complaint has also been registered.
Registered, my lord.
Both investigation is continuing.
Yes, my lord. But my humble submission before your lordships, in case of interreligion marriage, the marriage must be registered under Special Marriage Act.
That is the subject matter of your investigation.
My lord.
We are in habeas corpus petition. Yes. And forcibly attempted to take away Afroza to the petitioner's house. A complaint to that effect was lodged by Afroza herself on 15th of July 2023, and the same was registered as Narendrapur PS case number 651/23 dated 15th of July 2023. Mr. Chatterjee further submits that the statement of Afroza has also been recorded under section 164 of the code, wherein she has categorically stated that wherein she has stated that she is willingly residing with her parents. She has also disputed the matrimonial relationship and the allegation that she is pregnant.
My lord.
Let the report as place be kept on pendrive party. Heard the learned advocates appearing for the respective parties and considered the materials on record. The learned advocate appearing for the respondent numbers 5 and 6.
4 and 5.
4 and 5 also submits that Afroza is willingly resided at her parental house. And indisputably, both the petitioner and Afroza are adult. Petitioner alleges that he has married Afroza, and she has been forcibly kept, and she has not been allowed, she has not been allowed to return to her matrimonial house. She has been confined at her parental house. Afroza, however, by recording her statement under section 164 of the code, had categorically stated that she is willingly residing with her parents. Stop. The complaints lodged by the petitioner as well as by Afroza have been registered as an investigation in the same is still continuing. Stop in the said conspectus, and as we do not find any material to infer that Afroza has been illegally detained, we are not inclined to interfere.
Grateful, my lord.
In the present writ petition, stop the same is accordingly disposed of. Disposed. Yes.
Copy.
Item number 7, I am appealing on behalf of the petitioner. The affidavit of service, the wife of the petitioner, my lord, has been forced.
One pen drive.
Report. Your lordship, I am appearing for private respondent number 9 in the instant
My lord,
case.
the wife
Relief
of
to file Wakaratnama in the concerned department.
affidavit of service, my lord. The wife of the
Yes,
petitioner has
case
been, my lord,
Case
forcefully and illegally detained by the father-in-law, that is the respondent number 8, and my lord, another person, respondent number 9, my lord, on the ground that the petitioner and the, my lord, petitioner had the love relationship, and due to such love relationship, my lord, a marriage was solemnized, my lord. Since the petitioner belongs to the lower caste, my lord, it was not accepted by her parents, my lord. My lord, initially, marriage was solemnized on 13th September 2018, my lord. Thereafter, we stayed together. There was no complaint against the petitioner by the wife of any kind of torture, my lord, and any others, my lord. But suddenly, after in the year 2021, she left my house and went to the house of her parents on the ground that her mother is ill, my lord. Thereafter, she was being forced to, my lord, she was being, my lord, restrained from moving the in-laws house, my lord, and my lord, she has filed my lord, mutual divorce petition. Subsequently, it was informed to me that the mutual divorce was filed with a force, my lord. My lord, that was withdrawn, my lord, and in the court premises, the father-in-law has slapped the petitioner. I have lodged the GD. Subsequently, my lord, I have lodged the complaint, my lord, before the police station on 28th of February.
What happened to the mutual divorce?
My lord, that was being withdrawn. That was withdrawn, my lord.
Withdrawn by who?
By the husband.
By the petitioner,
Let
my
him
lord.
complete.
By the petitioner on the ground, my lord. It is initially it was under my my client's my lord, apprehension that the mutual divorce was filed, my lord, at her own volition, my lord. But subsequently, it came to his knowledge that it was, my lord, filed on the threat and, my lord, on being forced put upon my wife, my lord.
Then why did you withdraw the mutual divorce petition?
My lord, since the my lord, it was a love relationship, my lord.
Very good. Now matrimonial suit is pending, na?
No, my lord, it was withdrawn, my lord. I have annexed the order sheet and I have not suppressed it, my lord. I have stated and annexed the order sheet, my lord. But thereafter, I filed a complaint with the concerned police station on 28th of February 2022, my lord. On the ground that the wife of the petitioner has been illegally and forcefully, my lord, detained by the father-in-law and another person, my lord. And my lord, it is the apprehension of the petitioner that his wife has been given, my lord, marriage to respondent number 9 forcefully by the father-in-law, my lord.
You don't have any issues?
No, my lord.
So how habeas corpus, Mr.
My lord, kindly appreciate. We have lodged, my lord.
Both of you are adult.
My lord.
Now
My lord.
she has left your residence or forcibly taken away?
No, my lord. It is I have.
You led a matrimonial life for 3 years. 2018 was your marriage.
My lord.
Marriage has not yet been dissolved.
No, my lord. Not yet been dissolved.
If your wife does not want to reside,
my lord, that consent, whether my wife is willing to reside with
your complaint. When
my lord,
did you lodge the complaint?
my lord, page 87, P6, my lord.
87.
My lord.
When was it lodged? 28th February 2022.
Two, my lord.
And divorce petition was withdrawn.
My lord, subsequently, my lord. That is, my lord, at page,
It was on 7th December
my lord,
2022.
my lord, page 97, my lord,
So your matrimonial relationship subsists.
my lord.
Yes, why she is not,
My lord.
if she is willingly residing at their parents' house, how can court help you tell
My
us?
lord, she have already, or
Aha, abar kotha.
my lord,
My lord, my
Why don't you take your seat? We will call upon you.
my lord, yes, my lord. My lord, I appreciate, my lord, kindly appreciate, since the marriage is, my lord,
We are appreciating,
my lord,
but what can we do?
my lord, I just wanted to know whether my wife is residing at her parents' house on her own volition or not, my lord.
For that you have lodged a complaint.
My lord, I have lodged, that has not been addressed, my lord. That has not been addressed. No criminal case has been instituted, my lord.
আন্ডারস্ট্যান্ডিং করেছিল আচ্ছা সেইখানে বলছে নেভার কনজারভেটিভ
Yes.
For the private respondent number 8, Lordship.
8 and 9.
8 and 9. Yes, Lord. He is appearing for the 9.
So where is the girl? She
The
is
girl is
residing
with a parental house.
Uh-huh.
She is residing at a parental house.
Who are you?
I am respondent number 9.
Who is the father? BPness? Who is BPness?
Lordship, I am for the respondent number 8. She is residing with me on his
You are the father of the girl.
father of the girl, Lordship.
So she is residing at your house.
My house.
And who is this Chandan Pandey?
He is the family friend with whom they are alleging that she has an affair or something like that.
So that allegation is false.
Totally false, baseless.
But I have,
Very good. Yes, what do you say?
my lord, self-declaration was made, my lord, by the lady. Kindly see, before the police, that she is willingly residing with her parents, my lord.
my lord,
Yes, yes, yes.
Her complaint was registered, na?
Yes, my lord, complaint was registered, but as the case is purely on matrimonial dispute, my lord, there is no requirements of filing any FIR. So, my lord, case was inquired, and the lady,
Inquired.
yes, my lord, case was inquired, and the lady
We
gave
are asking you
self-declaration.
whether that FIR was registered.
No, my lord, this is a civil dispute.
We are asking you.
No, my
whether
lord, FIR was not lodged by the police.
my lord, may I submit one thing, my
Yeah,
lord?
just.
Complaint type of
Where is it?
57.
My lord, the respondent number 9, Learned Counsel appearing on behalf of the respondent number 9, stated that there is no, my lord, relationship with my wife. My lord, I have came up with some photographs which primarily reveals.
We are not on that.
Yeah.
My
We are
lord,
not on that.
she
You have
was
lodged a-
being
both of you
forcefully
are
married
adult.
with the respondent number 9, my lord.
That is an issue which
This
you
is
can
the
take it as-
photographs, my lord.
Photograph dekhi ko.
My lord, kindly appreciate, my lord, kindly 164 of the wife may be recorded, my lord, by the by any magistrate, my lord.
164 in connection with which?
Court complaint.
Which case?
But I have lodged
Case
the
has- No criminal case has been started.
এটাই লজ করেছে এটা কেন ক্রিমিনাল কেস রেজিস্টার করে Mr. Chatterjee, why you are not registering criminal case on the basis of annexure P6? You register, call the lady, record her 164, finish.
My lord, the police can record 164 statement if your lordship's direct. Otherwise, my lord, my humble submission before your
No, no,
lordship.
why our direction is required? If you treat this as a complaint, naturally she comes within the domain of this.
My lord, police will register, will take statement under section 164 of CRPC. My lord, but no FIR is required, my lord. There is no cognizable offense find out, my lord. Kindly see for a moment, my lord, the
It is
complaint.
disclosing, my lord, from my complaint at page 6.
One, the
The
mutual
complaint.
divorce petition was filed.
That was withdrawn, my lord.
Subsequently, it was withdrawn by the husband.
But she never come up with the concerned, my lord.
Oh,
court.
if
But
they have
kindly
not
one
registered,
direction, my lord, for my lord, kindly one direction, my lord, for taking up investigation of my P6, my lord, my representation.
156.
156, yes.
The present writ petition has been preferred primarily fearing for following relief. এটা কোট করে দিই। Mr. Rakib, learned advocate appearing for the petitioner submits that the petitioner married the petitioner, namely Biman Das, bracketing in short Biman, married what is the name of the lady?
Neha Pandey, man.
Neha Pandey. In short, Neha. On 13th of September 2018. And since then, he was retired. Since then, Neha was residing willingly with her at her matrimonial house. Stop. Subsequently, matrimonial disputes arose between the parties, and the parents and Neha's parents were matrimonial disputes arose between the parties, for which Neha's parents were instrumental. Stop. Stop. In the month of February 2021, during the COVID pandemic period, Neha was allowed to visit her parental house. But thereafter, Neha's parents illegally confined her at her illegally confined her. Stop. Mutual divorce কবে ছিল? Mutual divorce টা discuss
97 page numbers. 97 and 98.
14 সেটা উইথড্র হয়েছিল 7/12/2022।
কি বললে? Confined. Stop. A complaint to that effect was lodged, but the police authorities did not take any steps. Stop. Mr. Chatterjee, learned advocate appearing for the state, however, submits that it is a pure matrimonial dispute between two adult persons. Stop. Biman himself filed a matrimonial suit. A matrimonial suit was preferred. A matrimonial suit being suit number 1838 of 2021 was preferred by Neha. In which Biman himself filed an application কি করে করবে? হাজবেন্ড ফাইলস অ্যান অ্যাপ্লিকেশন ফর withdrawal তো ফাইল করেছে মহিলা।
না, দুজনেই ফাইল করেছে। মিউচুয়াল ডিভোর্স মানে
Mutual divorce?
জয়েন্ট পিটিশন।
Yes, my lord.
Mutual.
Under section 28 of Special Marriage Act.
পরেও
20 কি লিখলে? No, a mutual divorce petition was jointly filed by Biman and Neha, and the same was registered as match suit number 1838 of 2021. Subsequently, Biman withdrew the said suit on 7th of December 2022. As would be explicit from the ordered annexed at page 97 of the petition. Mr. Chatterjee further submits that a self-declaration was submitted by Neha before the officer in charge Zinzira police station, wherein she categorically stated that she was willingly residing with at her parental house. Stop, let a copy of the same as produced be kept on. The Mr.
Pranajit Roy, Lordship.
Mr. Royal Learned Advocate enters appearance on behalf of
Respondent number 8.
and Mr.
Mohala Nobish.
Mohala Nobish
For
Learned
respondent number 9.
Advocate enters appearance on behalf of the respondent number 9. Both of them denies and disputes the contention of the petitioner and submit that Neha is willingly residing at her parental house. Hon'ble learned advocates appearing the respective and consequently materials on record. উপরে ওই দেবব্রত চ্যাটার্জির ওখানে let the self declaration of Neha as placed be kept on record. Indisputably, both Biman and Neha are adult persons. They entered into a matrimonial relationship in the year 2020. In the year 2018, subsequently matrimonial disputes. Subsequently, their relationship was strained due to some matrimonial disputes. And Biman and Neha filed an application for mutual divorce. However, the said match suit was withdrawn by Biman. Stop. From the self-declaration of Neha as produced, it appears that she is willingly residing at her parental house at
their address to the
52B, BL Shahar Road, Behala, Kolkata 7. Stopping the said conspectus, and as we do not find any material to infer that Neha has been illegally detained, we are not inclined to interfere. In the present petition. Stop, the petitioner's prayer is refused and the writ petition is disposed of. Stop.
Grateful. May I get one copy of the
Yes, next.
number 8?
I have a very bad difficulty, my lord. My lord, Justice Banerjee's determination has been given to your lordship. My lord, today, my lord, we went to Justice Banerjee's court, my lord, in the morning, my lord. His lordship was not sitting, Justice Arijit Banerjee. Thereafter, my lord, at around 11:10, my lord, it was uploaded in the system, my lord, that my lord has the determination. I want to move an extremely urgent matter, my lord. May I come back? My lord, the urgent
Is this in his lordship's leave?
determination, my lord, the odd.
Is it appearing?
No. Well, I have to take leave and also move the matter. It concerns, my lord, a departmental inquiry and a suspension which has been, my lord, recommended by the Honorable.
It's appellate side, sir. It has to come in the list.
Maybe my lord, a supplementary list, maybe, my lord, maybe. Yes.
File it.
My lord,
It will appear tomorrow.
My lord-
Tomorrow his lordship doesn't sit, we take it up. No problem.
My lord, then my lord file.
You file the matter so that
It is listed before his lordship tomorrow.
listed I don't follow.
My lord, I have to take your lordship's kind leave to move the appeal without certified copy. Because the order was passed on Thursday. And we have applied for certified copy. My lord, I was only beseeching your lordship, if it commends to your lordship, to direct your lordship's officer to publish a supplementary list in my lord's court today at 2.
It is 48 hours is required, na?
No, but this will be, my matter will become infructuous.
Why it will become in
My lord, because the punishment and everything has been, suspension has been recommended.
suspension?
Suspension of the BDO and the SDO. My lord, this is, my lord, arising out of the panchayat matters. My lord, I shall serve and come, my lord, may I come back? Or if your lordship doesn't want, my lord, the matter to be listed in your lordship's court.
We can give you leave. Tomorrow you can, tomorrow the matter, whether 48 hours has to be given, then it will come in the.
My lord, it can come, my lord. Justice Banerjee's, I'm just telling your lordship, Justice Banerjee's system is, if the matter is urgent, he will not allow the matter to be listed on the day, but on the following day, that is tomorrow. My lord, may it appear tomorrow in his lordship's list, that much my lord can.
Leave the other. Leave the other. We cannot direct supplementary list to be there.
No, to be listed tomorrow. To be listed tomorrow as an urgent matter.
করে দিতে পারবে?
But it will appear tomorrow.
His lordship's list incorporation cannot be at our instance, na?
My lord, it is,
Cannot be
otherwise, my lord, I will be, my lord, beseeching your lordship.
Listen to us. We can give you the leave to file.
Mine.
You can approach the register for the purpose of including it in his lordship's list. Yes.
I'm great. My lord, only the leave has to be endorsed.
Leave granted. Yes.
Great.
My lord, 8, I appear for the petitioner.
To be listed tomorrow, if it is recorded, then my lord, whoever has the jurisdiction, my lord, it will appear there.
We cannot give at the time of granting this leave. No, this is the problem.
As your
This is
lordship.
the problem.
My lord, may I come back with the number and again mention, if your lordship so desires? And what happens is, my lord,
send it and say that as my lord has directed, register it tomorrow. This is exclusive jurisdiction of justice.
as your lordship. As your lordship. And in the event his lordship is not available, my lord, kindly permit me to move it tomorrow. My lord, that indication.
That you come back
I'm great.
thereafter.
Great.
Yes.
My lord, I appear for the petitioner. My lord, matter is relating to promotion and seniority, my lord. My lord, previous occasion I served notice to the respondents, but for a long back they are not appearing.
It is a hearing matter.
My lord, it was a long pending matter, my lord.
Hearing matter, direction.
Fresh by joint to fresh motion.
Lord, affidavits, there is no direction
Yeah.
for filing affidavit probably. My lord, it is running in the motion. My lord, the affidavit have been exchanged. I cannot find, my lord.
No, affidavit file the direction.
Lord, affidavit has not been exchanged, my lord.
But direction was given to file affidavit.
They did not file.
That means the matter cannot be stated to be at motion stage.
My lord, 2011 matter, a short point is involved. Point is not a a very big melody. If your lordship subject to lordship sanction, may it be taken up.
Uh,
My lord, petitioner is about 70 years old.
এই দেখি দিনটা
না, এটাকে
চালু চালু।
hearing এর topic দিতে হবে।
হ্যাঁ একটু দিন।
Censor
ওই টপে হিয়ারিং
censor
My lord, for a long period, they are not appearing.
must have appeared before the earlier bench also.
No, did not appear. They did not appear. Previous occasion, they appeared. They appeared, my lord, Justice Ashim Kumar Banerjee presided over the Honorable Division Bench, my lord.
That on 22nd of June,
They appeared. No,
they did not appear.
they did not appear.
That's not it. It okay that no?
Lord, none is appearing. Yes, my lord, he is not, none is appearing.
You complete service and
My lord, I have been directed, my lord, I have served notice, my lord. And my lord, my unfortunate thing is that the private respondent refused to accept, that has come back. And my lord, the service of the respondents, my lord, railway authority, that I, right now I couldn't find it, my lord, I have served admittedly. And the private respondent refused, that has come back to me. And my lord, once again, I may serve, my lord, subject to lordship's kind sanction. If your lordship may take it up any day, my lord, I shall take only 10 minutes time, my lord. May I come back serving once again, my lord?
was about you.
Yes, that direction was there. I have, my lord, I have served the, my lord, my lord, I'm submitting, my lord. What is the difficulties to me, my lord, that I have served to the railway authorities, but that the receipt I could not find right now. That is the difficulty. Once again, may I come back, and my lord, the private respondent refused. That is with me, my lord, on the basis of that service. My lord, grateful to your lordship. My lord, I shall. Grateful to your lordship.
আমরা একটি জিনিস my lord, in this matter একটু বলে নিন, in this matter my lord, I am
জিনিস দিলাম কি ধরনের ম্যাটার
বলে নিন আপনি, তোমার ভালো শুনে নাও। না না, শেষ তো আমার কিছু না, আমি মেন ম্যাটার
সিটি এটা হচ্ছে মোশন ডব্লিউপিসিটি হিয়ারিং সার্ভিস গ্রুপের অ্যাপ্লিকেশন এর সার্ভিস গ্রুপের হিয়ারিং কিছু অ্যাসাইন ম্যাটার আর কিছু রিভাইভ অ্যাপ্লিকেশন 4-5টা এবার ওই যদি একদিন
My lord, in this matter, I am instructed to appear on behalf of the respondent number 5 CBI. My lord, here the main answering respondent is railways. Only, my lord, subject to correction, my lord, some caustic remarks has been made by the petitioner against CBI. So, if your lordship kindly comes to para 6, page 6, para 11. Yes. No, I am the respondent.
In this
Yes.
matter, madam, Mr. PC Das appearing for the petitioner is today and tomorrow. Is there some difficulty? Let it be fixed on Wednesday, man.
Wednesday, I have
Next week or
difficulty,
next
my lord.
My lord, I have difficulty.
Not this week.
My lord, may I, my lord, subject to correction, submit? Very well.
10 in similar pair, man, is for the respondent.
Yes. No, this is my application.
10 is for the respondent. Mr. Das is for the respondent.
My lord, here, my lord, an order has already been passed, my lord, and the interim order has already been passed, and there is a stay of the, my lord, the proceedings before the Central Administrative Tribunal, my lord. There was contempt proceeding was pending, my lord. My lord.
Order.
Second copy. Second.
Have exchanged affidavits.
Lord, affidavit has been received. Affidavit in opposition. Moreover, my lord, he has already retired. This was, my lord, for the selection of the, my lord, from in group C, from D to C. My lord.
But for Union of India,
Union of India. My lord.
you are enjoying a stay. Enjoying a stay.
My lord, yes, stay has been granted.
Now, have they used opposition?
They have, my lord, the respondent has filed an opposition, affidavit in opposition. My lord. My lord, I have to, my lord, I have to file, my lord, reply. Not yet filed.
State Rolial and advocate for the case for extension of time. Set the record as time to file the affidavit.
My lord.
Copy page and copy
My
page
lord,
and
my lord, the affidavit in opposition, my learned, my lord, junior, my lord, a copy, my lord, directly, the respondent went in his chamber, my lord, and handed up over a copy of my lord. My lord. Have you got?
I have, it is doubtful. This is only told that I filed in court. If it is not in court, then so they have not filed.
I have no instruction, my lord. So that's matter. I have to check.
Got the opposition. You are not
No,
sure.
my lord.
My lord, I am told by my junior that a copy.
My lord, I am in dilemma that whether they have given me to not. I have phoned the respondent and he told me that he had filed the affidavit in opposition. So I have requested him to give me one copy so that I can file reply. They have not given me copy.
Why is the
No, I don't know, man. Let it be fixed, man. Next week, man, I will clarify.
Can you tell if they file?
please to ask them? State Rolial copy and.
My lord. My lord. A phrase, my lord, a phrase affidavit in opposition, if my lord intended to file. My lord.
Inquire whether opposition has been filed.
My lord.
Yes, madam. Every opposition is in file, ready, madam. Let it be kept on record.
Leave it.
Copy this.
No, no, copy to do.
Respondent.
Yes, respond. How is it today? I just put it chapter copy. Account
Mr. Pandey, Mr. S.K. Pandey.
Yes, my lord.
For Union of India.
Copy of
My lord.
এই এটা কি under
Grateful.
But I'm for the petitioner, my lord. I pray for 4 weeks time to file my affidavit reply, dealing a composite affidavit of reply, dealing with the original affidavit of opposition along with, my lord, recently handed over the supplementary affidavit of opposition.
Actually, I
Is
beg
it-
to,
Recently handed over to me,
the supplementary is only in regard to one annexure.
but I have to deal that, na?
One annexure only that has been wrongly annexed. Supplementary affidavit does not contain substantial.
I have to deal that.
dealing with the awareness of documents. একটা এফিডেভিট ইন অপোজিশন করেছে তার সঙ্গে আবার কি একটা সাপ্লিমেন্টারি এফিডেভিট ফাইল করেছে
Opposite, just to
Ah.
incorporate one annexure which was wrongly annexed in the opposition. I file it, no.
In opposition
And as well as supplementary.
সাপ্লিমেন্টারি এফিডেভিট
Copies as well.
But for the
Respondents.
sole respondent.
No, all the respondents. All.
The 36 respondents, they have appeared for all.
How they have acted in terms of the tribunal's order?
Lordship, in terms of the tribunal order, we are not given appointment.
Raise the preliminary objection. That's the entertainability since they have acted in terms of the tribunal's order.
Yes, Lordship, they have once called upon us, but due to some anomaly in the documents, they have not given us appointment.
Initially, department found that they could follow up the tribunal's order. Subsequently, on scrutiny, they found that all the claimants are not eligible. They are all false documents. They are not eligible for the permanency of their job. So, my lord, this appeal has been prepared. All documents have been annexed in the petition, my lord.
Viral and
Rajkrishna Mondal. Lordship, I am led by Mr. Gopal Chandra Ghosh.
the fight in connection, the opposition.
Opposition.
সাপ্লিমেন্টারি এফিডেভিট কিছু অ্যানেক্সারে গন্ডগোল হয়েছে সাবমিশন
This is supplementary to your opposition. Not
Lordship, in paragraph 5, page number 2.
Composite affidavit of reply, my lord. Composite affidavit of reply, dealing both of them.
How many petitioners? Union of Indians functionaries are there? You are appearing for railways.
All, my lord.
Find an evidence opposition dealing with the award. Awardments will it's such affidavit in reply 5 within
4 weeks, my lord.
not 2 weeks from the matter for finding.
Lordship.
4 weeks. Matter for finding.
What the time? नहीं है इसको दिखता नहीं This matter I am appearing for the respondents, my lord. I want to file an affidavit in opposition, my lord. The fact is slightly changed after filing the writ petition, my lord. That's why. If my lord goes through the order dated 2012-2022.
Sir, here to find this supplemented.
My affidavit is there before the tribunal, my lord. But my learned senior friend has submitted before this court. The tribunal proceeded with the wrong circular. So I want to consider the case of the respondent herein to the circular which is applicable. Thereafter they have considered, they have rejected again. That's why, my lord, I want to file the opposition, my lord.
No, I don't stand in the way.
2 weeks within the 2 weeks.
All the.
This is a case of compassionate appointment. I am fighting since 2013. My lord. Kindly fix a date, my lord. Everything.
It's there.
Stay already granted will continue. Stay already granted may continue.
I filed a contempt application that was already stayed. 4 is not kindly fix a date, my lord. Any date, my lord.
Stay already granted will continue.
Stay already granted for limited period.
No,
Yes.
until further order.
Until further.
I have already contempt application also adjourned synod before the time. Yes, my lord.
The finada is before the contempt petition before the tribunal is before that. No, kindly say the stay will continue. Nothing.
Stay granted on 2012-2022. Last para, in view of the direction made herein above, there shall be stay of all further proceedings in the contempt proceeding initiated before the tribunal teeth, 3rd week of the February 2023 or until further order, whichever is earlier.
No, after this.
তারপরে একটা অর্ডার হয়েছে তারপরে একটা কপিটা নেই ভেলুমন্ডির ঘরে
এই অর্ডারটা
ওই একটা ফুল কপি নেই স্যার আমার কাছে যেটা আছে কিন্তু নেই পুরো প্রিন্ট আউট ভালো আছে ওখানে লেখা নেই স্টে এর কথা কিছু
Was Mr. Gupta, they are first in February. Now we can sign a
they have been submitted we have consented that let the matter be not pressed by the contempt application. Yes, my lord, Mr. Das is for the respondent, my lord, kindly consider next week.
14, I am for the petitioner, my lord.
I appear for the respondent.
My lord, kindly peruse page 78 for a moment, my lord.
'78.
78, my lord. So it starts from 76, my lord. The earlier order of the Honorable Tribunal.
Yes.
My lord, at page 78, my lord, para 4. Accordingly, without entering into the merits of the case, we hereby direct the respondent number 1, namely the Secretary, Ministry of Women and Child Development, to pass a reasoned and speaking order in accordance with law within a period of 6 weeks from the date of receipt of this order, and to communicate the decision forthwith to the applicant, my lord. The judicial pronouncement as cited by the applicant in this original application should be referred to while deciding on the prayer of the applicant, my lord. And thereafter, my lord, they have issued the speaking order, first speaking order at page 80, my lord, 80.
Page 80.
80, my lord. And 81. Well, here, my lord, 2 points are there, my lord. The first point is that, my lord, there is a specific direction that the speaking order to be issued by the respondent number 1, that is Secretary, Ministry of Women and Child Development. But that has not been done. That has been issued by one deputy director, my lord. That was not the direction. That is number 1. And thereafter, my lord, and surprisingly, my lord, they have issued another speaking order, one parallel speaking order, my lord, which appears to me prima facie impossible, my lord. At page 82, my lord. By the same incompetent authority, my lord.
Did this order refer to the earlier order?
No, my lord, nothing. They referred to the order of the Honorable Tribunal. Actually, 2 parallel speaking orders has been issued on the same order of the Honorable Tribunal.
What was your main case about?
My lord, my main case is about the MSCP benefit, my lord. My lord, before coming to that, my lord, let me kindly be allowed for a minute, my lord. Regarding this matter, my lord, earlier coordinated bench of this Honorable Court, my lord, they have issued one order, my lord. And according to that, my lord, the respondent side has submitted one speaking order, one statement, my lord, on the earlier date, my lord. That is note number 64, 65 onwards, my lord.
You have already retired?
Yes, my lord, I have already retired.
Now, you have challenged the tribunal's order.
My lord?
This petition has been filed by you.
Yes, my lord.
So you are aggrieved by the direction to pass a speaking order.
My lord, here the issue is twofold, my lord. One is the irregular speaking order, my lord, and which has been upheld by the Honorable Tribunal. And I am challenging the tribunal order, my lord. So
that order.
Yes, my lord. That is at
First order you showed us at page 76, that is of the tribunal's order.
Yes, my lord.
9th of August 2018.
My lord.
On the basis of that, they passed first a reasoned order on 24th September 2018.
Yes, my lord.
Thereafter, another order on 18th February.
Yes, my lord. By same
right. Then what happened? Did you again go back to the tribunal?
No, my lord. Oh, I'm sorry, my lord. Yes, I went back to the tribunal, my lord, challenging that order.
Yes, where is that order?
That is order is at page, my lord, after 156, my lord. After 152, I am sorry, after 152.
Now, now what your claim was rejected.
My lord.
So there is no scope for any interim order. Is there any scope for
No, my
interim order?
No, my lord.
Then this has to be hard.
Yes, my lord.
Now, was it on joint pleadings were exchanged by the parties?
Yes.
Yes, my lord, at the tribunal.
Before the tribunal, the reply and rejoinder was exchanged. Now, my lord, the points which are being taken by my learned friend, my lord, those have been dealt with in the impugned order. So,
Yes.
and my lord, the petitioner before your lordship has retired long back. He is possibly senior citizen. Senior citizen, obviously.
Yes, my lord.
He has crossed.
After retirement, everyone is serious.
No, একটু অনেক বেশি বয়সী না মিনার বয়স বোধহয় অনেকটাই বেশি দেখুন
So so there is no utility in using any further opposition.
No, it should be hard. It should be
It
hard.
requires to be hard, my lord.
So we are fixing it up. We will hear it finally.
Yes.
My lord,
We will hear it finally. We are fixing it up.
my lord, can your lordship not hear it today, my lord? Because the applicant is suffering, my lord.
Yes, we shall hear because this is under, we thought that these are new matters under the tribunal application.
Yes, my lord. This is a new motion, no doubt.
So the present writ petition has been preferred, challenging an order dated
9th November 2022.
9th November 2022. Hey, Jayantu. It's appearing for the parties. We have been informed that the parties have exchanged their pleadings. We have been stop. The pleadings are the reply rejoinder are annexed here.
My lord, my lord, my lord.
We have been informed that the parties filed their reply and rejoinder in the original application, which have already been annexed to the present.
My lord, my lord.
In view thereof, list the matter as for orders. Daily supplementary list of this court on 22nd August.
20 hours.
As for orders, it will appear in the supplementary list. We will hear it.
My lord.
I'm grateful to
20 seconds. জগদীশ রঞ্জন দাস আমি অ্যাডভোকেট নাম রেকর্ড আছি হ্যাঁ অ্যাডভোকেট নাম রেকর্ড আছে
But what is this note sheet, Mr. Roy?
Lord, on the other day, the honorable coordinate bench directed us that whether it was the speaking order was passed by the secretary or not. So we wanted from the department concerned. So it was circulated up to secretary, and the speaking order was signed by some other authority, not by the secretary, but the approval was taken from the secretary. That's why the note sheet was filed.
And there also, my lord, there is in their note sheet, my lord, the their internal direction is.
It has been filed here
Yes,
pursuant to the
yes,
earlier order.
yes.
But there is the voting for corrigendum PPO, but they have sorry, corrigendum order, but corrigendum speaking order, but they have issued one parallel new speaking order, my lord.
That note sheet is here.
Yes, my lord, that note.
We will finally hear.
My,
It was filed on the other day. Lord.
Yes.
22 বললেন না জজ স্যার 22 My lord, I am appearing for the petitioner, but my lord, I am sorry to trouble your lordship that my lord kindly take this matter day after tomorrow because everything I have forgotten. I have to prepare it.
I'm sorry.
Only day after tomorrow, only day after tomorrow. I understand, Mr. My learned friend is annoyed because he is appearing for the respondent number 1.
I'm
No,
also
that's
very
okay.
sorry.
But
I'm very deeply
I'm-
sorry.
I'm under compelling circumstance, my lord, I have paid for this accommodation.
No, because of the reason your lordship will kindly see, the order dated 15 March
Yeah,
2023.
that is what we are seeing. 15th March,
15 March 2023.
a spiritual leave is granted to file a supplementary FD.
Not yet.
You have not yet filed the supplementary.
And lordship will kindly 19 June order. Yes.
As a supplementary affidavit filed got directions.
Twice direction was given
My
to
lord,
file
the-
supplementary.
And my lord, we are the terrible victims.
My lord, the
My
learned
lord,
advocate on
keeping
record,
this, my lord, keeping this matter pending, a consideration by which my learned friend was aggrieved, he made an appeal. And in the meantime, while this matter is pending, my lord, 2 times we have been superseded,
my lord,
taking advantage of the matter pending. It is a ploy. I'm deeply sorry, my lord, that I am opposing this, that because my clients are really in tears,
my lord, I
that we are
cannot,
going to retire, and 2 times we have been superseded because the matter is pending and they want to submit a supplementary affidavit.
my lord, I do not know because learned advocate on record, Mrs. Shaini Raichodri,
You are appearing for whom? Union of India.
Union of India.
So you
As-
yourself said that you will file a
Yes,
supplementary.
my lord,
Who
possibly,
is your junior? Mr. Chu?
possibly,
Who is your junior?
Mrs. Shaini Raichodri. She is sick, my lord.
এই কোন ফাইলটা দিয়েছো? হ্যাঁ, অভিরূপ রয় সান্যাল appeared.
Shaini Raichodri on 15th March 2023.
He himself prepared.
Yes, my lord.
My learned
And
friend
I believe that has been prepared. But she is not coming to court. She is badly suffering.
What is your prayer? What
My
is
lord,
your?
only day after tomorrow I
You are not filing the supplementary affidavit.
possibly because I have.
Then
prepared it.
again it will appear day after
No,
tomorrow. You
no,
will
my
say,
lord, my lord,
No, no.
whatever it is, I shall make submission on the basis of writ petition. If it is not prepared.
no, if you prepare and give it to Mr. Ali,
Yeah.
then he has a right to go through
Yeah,
it.
yeah.
Huh?
Yes.
So you tell us, finally decide and tell us, are you filing a supplementary affidavit or not?
My lord, possibly it has
Because
been.
if we keep it on the next day, maybe you will come with a supplementary affidavit. Then Mr. Ali has to consider it. Is it not?
My lord, on the 15th March, and I'm sorry, my lord, I'm taking, because it's not a cross thing.
Sorry, Mr. Ali,
But
we
I
are
will
keeping
wait.
it. We are keeping it as forwarders on a particular day. If you want to use a supplementary, give an advance copy to Mr. Ali.
My lord.
Huh? Tell us when you will do it.
Let it appear as for order. Khushi.
We will keep it as forwarders.
My lord.
If you want to use a supplementary affidavit, use in the meantime and give an advance.
My lord.
Pardon, Mr.
Mr. PC Das appearing for the respondent number 1. He is the original applicant.
Then Mr. Ali is
For respondent number 5 and 6, I think so.
Who is appearing for respondent number 1?
Mr. Das, original applicant.
Mr. Ali and you are similarly placed.
Not similar, exact. We have been made party as a private respondent in the original application. I am the original applicant.
And
This is for the private respondent in the original application.
oh, I see.
So advocate on record is changed or what? Hey, তোমার advocate on record change হয়েছে?
না 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 চেঞ্জ হয়নি ও
That appears to be this.
কোনটা ওটা অন্য এসছিল ওর জুনিয়র ও ওর নামে বদল My lord, kindly let me have 2 weeks time then.
No, no, no.
Keep it as for order.
My friend wants the day after tomorrow, he told me.
No, my lord, asking for
No, no, my lord can say it after two years. It is all right, but you approach me. এটা কি কথা বলছি? এটা তো ঠিক নয় না?
কোন heading আছে?
We are keeping it on 8th as forwarders. If you want to use any supplementary affidavit, you give it to Mr. Ali.
My lord.
Yes.
Only.
And Mr. Bhattacharya, advocate appearing for the petitioners.
R.J. Bhattacharya. R.J. Bhattacharya.
Mr. Bhattacharya, advocate appearing for the petitioner. Is for extension of time to file the supplementary affidavit. It's a supplementary affidavit filed within 4th August with a copy to the learned advocates appearing for the respondents. So Mr. Ali, learned senior advocate, enters appearance on behalf of the respondent numbers.
5 and 6.
5 and 6. 5 and 6. I am appearing for 5 and 6.
5 and 6.
আপনার ইয়েটা একটু দিয়ে দেবেন তাহলে কপি সার্ভিস করে
Number?
কোথায় বসেন একটু নাম আর নাম
Supplementary. Within 4 weeks, within 4th August. With copies to the learned advocates appeared for the respective respondents. This the matter as for orders in the daily supplementary status code on 8th August.
This is on the 8th.
But
On 8th.
8th.
8th, yes.
And by 4 he will, by 4th August, if he wants to file, he will file it by 4th August and give a copy to you.
Yes.
Their appearance.
আপনাকে অ্যাড্রেস করুন আপনাকে অ্যাড্রেস করুন ট্রাই করো আমার কোনো অ্যাড্রেস থাকে
Lordship, I am for the respondent. My lord,
My lord, I beg to appear on behalf of the petition.
my lord, the learned advocate on record, Mr. Chakraborty, he is presently on his legs on court number 238. So I'm praying for him not today, before your lordship.
It is for final hearing.
My lord, it was final hearing and it was heard by the divisionment of Justice Velumani, presided over by Justice Velumani. But after it was heard, my lord, it was likely to come for order, but subsequently, my lord, is in session over the determination. So, my lord, your lordship has to hear it again.
What is the issue?
My lord, the issue is regarding a promotion which was challenged. My lord, it was not denied. My lord, as per the policy, after retirement, you cannot get promotion. He retired. My lord, the petitioners, my lord, the respondents, my lord, they joined as inspector in the income tax department, my lord. My lord, they were promoted from time to time. And my lord, on 27/10/2011, my lord, they were promoted on ad hoc basis in the rank of JCIT. My lord, that is there, my lord, they have admitted in paragraph 6, page 6. My lord, the order impugned, my lord, is before that, my lord, 2 minutes of my lord's order. I will just play. So, my lord, they were promoted in an ad hoc basis. The applicants are no, my lord. The respondent was before the petitioners were the respondent before the tribunal. My lord, and agreed by the order of the tribunal, my lord, this WPCT. I am Union of India, my lord. My lord, so they were, my lord, promoted on an ad hoc basis on 27/11 to 27/10/2011, and my lord, respondent number 1 and 2, my lord, retired on 30/10/2015. Respondent number 3, these are all very relevant date, my lord, 30/4/2015. My lord, and my lord, without regularization of their post, they were promoted on an ad hoc basis, and without being regularization in the post of JCIT, my lord, they retired, my lord. After their retirement, my lord, the order of promotion come out from the department. The order of promotion comes out after their retirement on 31/12/2015.
Giving effect to?
My lord, the giving retrospective effect, no prospective effect. My lord, now they have claimed that because the policy decision of the government, which I'll reflect, my lord, said that those who were liable to be promoted, their name also to be included, even if they have retired, but they will not be considered as promotion. That is there, my lord, at page 71 of the requisition. My lord, against them, the rejection, they have not been allowed, they have not been given the effect of promotion, against which they have gone before the tribunal, and tribunal has now passed an order to give a my lord, the order impugned is at page 58, my lord. 29th August 1922, page 58. My lord. Paragraph 9, my lord. Tribush. Para 9. Para 9. Para 8, para 9. Yes, my lord. Were directed to grant arrears of pay allowance from the date when such retrospective preparation has been due to the applicant commission also holds good. We would accordingly direct the respondent authority to consider the case of the appellant in the right of this judgment and to decide within a period of 16 weeks from the date of receipt of the copy of this order. My lord, because, my lord, we have their prayer before the tribunal was, my lord, if your lordship kindly comes to the prayer, my lord, prayer is at, my lord, the prayer is at, my lord, at page 50, my lord. Before the application before the tribunal, page 50, my lord. My lord, there are 4 prayers, my lord. The prayer starts as 49, my lord. There the relief came. Page 49, my lord, the relief claimed, and my lord, the reliefs are there. The letter number this dated 28/4/2006, issued by the Under Secretary of the Government of India, cannot be sustained in the eye of law, and therefore they should be squashed. That is a policy decision of the government. That policy decision they want to quash, my lord. And my lord, order directing the respondent to regularize the my lord. My lord, they have stated that to consider this.
You consider?
Tribunal has not quashed your policies. Tribunal has said that consider their case in the light of the previous judgment. To distinguish and dismiss what is the problem. My lord, my lord can also, because my lord, the tribunal, when I sent a matter for your consideration, I decide to issue. No, my lord. That in facts and circumstances you consider it. You will consider it, who is talking. If you can show us that while passing that order, the tribunal has arrived at any categorical findings, then this delegation for reconsideration becomes odious. Then only we can consider. My lord, one of the observations, my lord, is my lord, this observation, my lord. Yes, my lord. From the order, what is your ground in this?
বলতে চাইছে এইগুলো অ্যাপ্লিকেবল হবে না, এই দুটো জাজমেন্ট কি আর
My lord, one of the observations, my lord, I'm replacing it, my lord. Just a minute, my lord. Is the order. Order you, let us read. My lord, that starts, my lord, really starts at page 59, my lord. My lord, the appellants have approached this tribunal under section 19 of the Administrative Tribunal Act 1985, seeking specific direction for regularization of the promotion of the applicant in grade of JICT with effect from 1/2/2012, because this is the date, my lord, before which they have retired. 1/2/2012, my lord, they are telling that to consider it when the date when they are given the ad hoc promotion. For award of NFGS with effect from the date of their eligibility, the applicant in particular would seek the following relief. The letter number is
Such and such.
does this dated 28/4/2016, issued by the Under Secretary to the Government of India, cannot be sustained in the eye of law, and therefore the same may be squashed. An order directing the respondent to regularize the promotion of the appellant in the grade of JCIT with effect from 1/1/2012, eligibility dates, and also to award NFGSG with effect from the date of eligibility and to grant ages. My lord, that means the ad hoc promotion, they are telling the benefits, my lord. An order do issue directing the respondent to fix the pension and other pensionary benefits and of the applicant regularizing their promotion in grade of JCIT and thereafter awarding them benefit of NFGS with the effect from the date of. So regularization after promotion, after retirement. Leave may be granted to other applicants to file this original application jointly under 4A or 4.5 or under 4 subsection 5A of CAT Procedure Rules 1987. Heard the learned counsel, examines pleadings and documents on record. Written notes of argument has been preferred by both the learned counsel. Then paragraph 3. The fact as ascertained from the pleadings are that the applicants were initially appointed as inspector of income tax, subsequently promoted to the post of income tax officers, and thereafter to the post of assistant commissioner of income tax on 5/12/2003 and 27/9/2002 respectively, that by the order dated 21/4/2008, they were promoted to the post of Deputy Commissioner of Income Tax with respective effect from 1/1/2007 and thereafter as Joint Commissioner of Income Tax on ad hoc basis by order dated 27/10/2011. Such appointments, however, being guided by DOPT dated 33/88 and that dated 3/4/2003 would categorically provide that such ad hoc appointment was limited to a period of 1 year only, and in the case of compulsive extension of ad hoc appointment beyond 1 year, the approval of DOPT, Department of Post and Telegraph, is required. The applicants who were appointed on such post of JCIT on ad hoc basis continues as such from 27/10/2011 till their dates of superannuation, that is 31/10/2015 in case of applicant number 1 and 2 and 34/2015 in case of applicant number 3. Their service period as ad hoc JCIT was not regularized, nor was any approval for their extension in such ad hoc tenure. JCIT short from DOPT with respect to all 133 officers who have been appointed as ad hoc JCIT on 27/10/2011. That on 31/12/2015, the authority issued an order bearing number 255 of 2015, whereby the service of the ad hoc JCIT appointed by order dated 27/10/2011 were regularized and subsequently awarded with NFGS in pay band 4 with grade pay of 8700 with effect from their date of regularization. So, my lord, that pay band 4 was paid from the date of regularization only. They are telling because they were entitled to, they are entitled to this pay band 4. This is the prayer. October 2011. My lord, they were appointed by order. It was ad hoc appointment, my lord. Ad hoc. Beyond 1 year, my lord. It has to be approved by the authority. So that is what we have done. My lord, no approval came, sir. That on 31st of December, authority issued an order. Yes, my lord. 31st of December 2015, after their retirement, they retired, my lord, on before that. Regularize their promotion. We do not. They retired in the post of Joint Commissioner of Income Tax, which they was given on ad hoc basis. Their provision was not regularized. Their post was never regularized, my lord. That is the question. That is the dispute, my lord.
Where is the 27th October,
My lord.
2011?
My lord, on 31st 12/2015, the authorities issued an order dated at. My lord, before that, my lord will find. No. My lord, order bearing number 255 of 2015, whereby the service of ad hoc JATICs appointed by order dated ATO were regularized, as subsequently with awarded with postgrade in this, with effect their date of regularization, with effect from the date of their regularization. So, my lord, it was when they were regularized that this payment for came into. That is the challenge, my lord. That is where they have challenged that no, we are also entitled. By an order of 27th of October 2011. My lord, but it was issued on 31/12/2015. It was regularized, whereby services of ad hoc JCIPs appointed on 27th October were regularized. My lord, your contention is that this regularization is actually from 31st December 2015. That is subsequent to their retirement. My lord, so why did you give the benefit? Why, my lord, we give the benefit to someone who were regularized. Their dates of regularization. My lord, because of that is why the policy decision comes up, my lord. The policy decision is 71, my lord. Then what happened? Yes, my lord. As the instant applicant has superannuated without receiving the benefits of regularization and the award of NFGS in pay band 4, such prospective regularization resulted in massive discrepancy among the official who has retired in the calendar year 2015 and the existing official who have been regularized as JCIT with effect from 31/12/2015. The applicants would claim that all the officers of 2002 and the left out of 2001 batch were eligible for promotions, but this is what the claim of the applicant, or were eligible for promotion to the post of JCIT with effect from 1/1/2012, as well as placement in NFGST scale pay band 4 with grade pay of rupees 8700 with effect from 1/1/15, as they have satisfied the eligibility condition on completion of 13 years of service, and that sufficient number of regular posts were available for appointing them on regular basis. The applicant would further avert that as such arbitrary regularization was made after a gap of nearly 3 years, namely with effect from 31/12/2015, and without any reason. The applicants have compelled to suffer significant financial loss as they were not regularized in time on account of unwarranted administrative delay. So, my lord, this is what they claim. Then, my lord, the applicant has represented on 25/2/2016 to the respondent number 2, who is the chairman CBDT, praying for antedating their promotion to the post of JCIT and placement in NFST. They were informed on 28/4/2016, however, that prior to forwarding any proposal to UPSC for conduct of departmental promotional committee, a large number of formalities had to be completed in accordance with the extant guidelines. The applicants were further informed that in pursuance of DOPT office memo dated 14/11/2014, although the names of the retired employee were included in the panel, such retired employee will have no right to actual promotion. That is the policy decision, my lord, which has been annexed here. A government policy decision, I've referred the judgment which is there in the record, my lord, which cannot be. It is a policy decision of the government. Accordingly, the following principle enunciated in DOPT office memo dated 9/4/1996, the name of the applicants were included in the eligibility list, and departmental promotional committee held on 29/12/2015 took up the issue of regularization of the applicants. The promotional orders were issued on 31/12/2015 after their retirement. As the applicants have superannuated by then, they were not available to hold responsibility in their higher post. They were deprived of regularization, promotion, as well as placement in NFGS. The applicants would aver that in terms of office memo dated 14/11/2000 had the departmental promotional committee been held in time, the applicant would have been in the zone of consideration as serving official to reap the benefit of actual promotion. The applicant would also state that as after their ad hoc promotion to the post of JCIT via order dated 27/10/2011, the officers continued as JCIT to work, but there was no attempt by the authorities to forward the proposal of regularization to UPSC for conduct of the DPC. The applicant would allege that they have hence suffered on account of undue delay in conduct of DPC by the respondent authority concerned. My lord, the applicant to seek to support their claim in the light of ratio contained in Union of India and others versus Imraj Chauhan 2010-4 SCC 290, wherein it was held that as the applicant government had not offered any possible explanation for delay exercise of statutory functions, the respondent, namely who were the petitioners before the Honorable High Court, should not be made responsible in the matter of promotion when there is a failure on the part of the authorities in conduct of timely exercise in holding the DPC. In Hemraj Supra, it was further held that the court should keep in mind the constitutional obligation of both the appellants, central government, as also the state government, who are to act as a model employer and act consistently in the role as welfare state, and that is an accepted legal position that the right of eligible employees to be considered for promotion is almost a part of the fundamental right guaranteed under Article 16 of the Constitution of India, and the guarantee of fair consideration in the matter of promotion virtually flows from the right of equality shrined in Article 14 of the Constitution of India. Learned counsel for the appellant would highlight the ratio contained in Hemraj Supra that the cadre view should operate from the point of time when the cadre view actually becomes due. The applicants also rely on PN Premachandran versus State of Kerala and others reported in 2004 SCC Labor and Service 170, in which the Honorable Apex Court has held as delay in convening the DPC occurred on account of administrative lapse, the promotees could not be made to suffer for no fault of theirs. Closer to home, the applicant would rely on the ratio in OA number 116 of 2003, Devmallo Boshu and 9 others versus Union of India, wherein the tribunal has directed the respondent authorities as follows. In view of the above, the OA is allowed. It is declared that the applicants are deemed to have been promoted in JTS cadre 1991, 92, and 93, as the case may be, depending upon their seniority position and availability of vacancies. And correspondingly, they were deemed to have become eligible for consideration to the next post of STS after completion of 3 years of service in JTS grade. The vacancy position of 1991, 92, and 93 shall be worked out at the rate of 2:3 of the direct recruit appointment for this years, as this is the ratio of the promotee and direct recruits under the rules. Such promotions shall be only national till the date of filing of OA and only notional till the date of filing of the OA, and the actual financial effect will be from January 1996, as it is only when then the applicant have moved their tribunal challenging the delay in considering the promotions via way number 67 of 1996. The respondent shall pass suitable orders after convening review Departmental Promotional Committee for JTS post and regular DPC in respect of STS post workout. The pay of the applicant on promotion both on the JTS and STS and arrive at a pay due on 1/1/96. The arrear of pay and advance for the period 1/1/96 shall be paid to the applicant that before sending a proposal to DOPT for conduct of DPT, certain formalities have to be completed, such as collection and removal of deficiency in recognizable APAR, ACR, and on completion of the requisite formalities, the proposal for vacancy year of 2012-13, for which 2002 batch IRS officers become eligible for promotion to the post of JCIT on regular basis, were sent to UPSC in November 2014. That a meeting of DPC was held on 29/12/2015, when 152 officers were recommended, being found fit for promotion in the grade of JCIT. A promotion order dated 31/12/2015, followed by which 112 officers were promoted to the grade of JCIT, where 29 officers who have retired on attaining the age of superannuation, barring one officer who has expired in June 2014, although considered fit for promotion, but but not granted actual promotion on account of this actual superannuation prior to taking responsibility to the higher post. This is our case, Mila. That in terms of DOPT office memo dated 14/11/2014, although names of retired official may be included in the panel, such retired officer would, however, have no right for actual promotion. I'll refer to that, Milord, policy decision of the government, that such JAG officer who has entered the 14 years of Group A of the Indian Revenue Service on 1st January of the year, following the year of examination on the basis of which the officer have actually been recruited or promoted to grade A, were eligible for NFSG. That while seeking the promotion proposal for promotion promoting 2002 batch officer to the post of JCIT, the UPSC has raised certain issues, particularly on relaxation of residency period, and that such relaxation were not agreed by the DOPT. Accordingly, the vacation year was changed to 2012-13, as the officer were not fulfilling eligibility criteria during the year 2011-12, becoming eligible for NFSG and for promotion to the regular post of JCIT with immediate effect. The respondent would also aver that the applicants had not challenged the DOPT office memo dated 14/11/2014, in which it clearly read down that retired officials, although considered eligible for a promotion, would not actually be entitled to promotion and not have a right to promotion. And accordingly, the respondent would claim that the original applicant has no merit and deserves to be dismissed, because the policy decision was never challenged. It remained, Miller. It was not challenged, admittedly non-challenged. We have carefully considered the rival contention and have examined the judicial ratio placed before us. We infer as follows: that undisputedly the applicants were promoted on ad hoc basis to the post of JCIT as on 27/10/2011. The Department of Post and Telegram office memo dated 33/1988 and 3/4/2013 made it clear that such ad hoc appointment is limited to 1 year only, and only in the case of compulsive expansion should DOPT approval be obtained by the authorities concerned. It has been admitted by the respondent authority hearing that order dated 27/10/2011 appointing the applicants as JCIT on ad hoc basis were neither withdrawn nor confirmed with prior approval of DOPT. Accordingly, the inaction of the respondent authorities in not taking a firm decision on the extension of JCIT on ad hoc basis after 1 year with effect from 27/2011 smacks of administrative apathy and non-compliance of the provision of DOPT office memo, my lord. Not only have the respondent failed to obtain a confirmation to the continuation of the appellant on ad hoc basis, but they have also failed to move UPSC at the relevant point of time, as admittedly the promotion was only sent to UPSC on November 14th after completion of the requirements. Here, my lord, the explanation has been given in the judgment itself, why we get delayed. That explanation is in the judgment, what we have stated. It is there, my lord. That it is not the case where no explanation has been given. My lord, the other, my lord, what we have submitted. My lord, if your lordship kindly comes to page 64, my lord. Yes, my lord, my lord, my lord. Page 6, then my lord, we are continuing with page 60. Yes, my lord, page 65, my lord, we are continuing. Yeah, my lord, it is in the
order impugned.
Yes, my lord, I'm referring. In the event, my lord, I'm page in the event the applicants were not being extended as ad hoc JCITs with prior approval from DOPT after 26/10/2012. The respondent authority should have done their homework in completing the requisite formality. It must be D, my lord, not he. Completing the requisite formalities in the year 2011-12, so as to move UPSC for conduct of DPC for promotion to the regular post of JCIT before the tenure of the applicant as ad hoc JCIT come to an end in October 2012. The respondent have failed to provide any convincing explanation as to why it took them nearly 4 years to complete the requisite formalities, such as collection of APAR, ACR, etc., attempt at futile relaxation, and to move UPSC only in the fag end of the calendar year 2014. We also find that a fruitless exercise praying for regularization in qualifying service in the senior time scale in the vacancy year 2011-12 was sent to DOPT, who, not having been convinced, did not agree with such relaxation, resulting in a change of the vacancy year to 2012-13. Consequent to this unproductive and abortive exercise of exchange of communication with DOPT in October 2013, the DPC could only be held on 29/12/2015. The authorities should have been more vigilant, given the fact that a large number of ad hoc JCIT was about to superannuate in the calendar year 2015. Hence, this tribunal would be of the considered opinion that the respondent authorities have not performed their entrusted duty so as to demonstrate proactivity and timely due diligence so as to move UPSC for conduct of DPC at the earliest opportunity, in not having resolved procedural issues such as collection of APAR, ACR, and to reach finality on issues of residency period well within time. In Nirmal Chandra Bhattacharya and others versus Union of India and others, 1991 supplement, column 2, SCC 363, the Honorable Apex Court, while deliberating on the issue of timely promotion, held that an employee cannot be made to suffer on account of intervening events. In Prem Chandran Supra, the Honorable Apex Court had held as follows. It is not in dispute that the posts were to be filled up by promotion. We fail to understand how the appellant, keeping in view the facts and circumstances of this case, would question the retrospective promotion granted to the private respondent herein. It is not disputed that in view of the administrative lapse, The Departmental Promotion Committee did not hold a sitting from 1964 to 80. The respondent could not suffer wings to the administrative lapse on the part of the state of Kerala for no fault on their part. It is also not disputed that in ordinary course, they were entitled to be promoted to the post of assistant director in the event a departmental promotion committee has been constituted in due time. In that view of the matter, it must be held that the state of Kerala took a conscious decision to the effect that those who have been acting in a higher post for a long time, although on temporary basis, but were qualified at the time when they are so promoted and found to be eligible by the departmental promotion committee at the later date, should be promoted with retrospective effect. Here the promotion was given by Kerala and then it is challenged. Here this is thus the reverse, my lord, where the as per the decision, policy decision,
this retrospective promotion which was given to the persons, that was challenged by that was challenged before the Supreme.
my lord.
Struck it down and said that no, you have to give them. That is the point. That is the point.
My lord, here the state of Kerala, my lord.
Conscious decision.
My lord, yes, my lord. Here the Kerala, the government of Kerala, the policy decision of the government is to give an effect. My lord, if your lordship kindly calls to this, here the decision of the government was to give an effect. Give an effect, retrospective effect after they are superannuated. My lord, no. Here the policy decision is squarely opposite. My lord.
What is your policy decision?
My lord, if your lordship kindly once have a look at page 71. My lord, once away. That is just the reverse, my lord. My lord, my lord. In ratio in Premchandran Supra is squarely applicable in the case of the present applicant. The ratio in Debmallo Supra, wherein the authorities were directed to grant arrears of pay and allowance from the date when such retrospective promotion has become due to the applicant concerned, where also holds good. We would accordingly direct the respondent authority to consider the case of the applicant in the rhyme of Premchandran Supra and Debmallo Supra and to decide within a period of 16 weeks from the date of receipt of the copy of this order. Admissible benefits, if any, are to be disbursed to the applicant concerned with the further period of 2 years. Now, my lord, there, my lord will find out that Kerala state took a decision that they will give a retrospective effect, and the policy was to give an effect. Here, my lord, the policy is just the reverse. If your lordship kindly comes to the policy, my lord, I will pay at his page 71. The policy is just the reverse here in this case. My lord, that is the office memo, my lord. Common India, my lord. My lord, if your lordship kindly comes to paragraph 3, my lord, which is relevant, my lord. The matter has been examined in consultation with the Ministry of Law, Department of Legal Affairs. It may be pointed out in this regard that there was no specific bar in the aforesaid office memo dated April 10, 1989 or any other related instruction of the Department of Personal Training for consideration of the retired employee where preparing year-wise panels were within the zone of consideration in the relevant years. According to the legal opinion also, it would not be in order if the eligible employees were within the zone of consideration for the relevant years, but were not actually in service when the DPC is being held are not considered while preparing year-wise zone of consideration panel, and consequently their junior are considered in their place would have not been in the zone of consideration if the DPC had been held in time. This is a considered imperative to identify the correct zone of consideration for relevant years. Names of retired officials may also be included in panels. Then, my lord, such retired official would, however, have no right for actual promotion. This is the policy decision, whereas it is a reverse than that of Kerala. Kerala took a decision of giving the promotion. Here, the policy decision of Union of India is to give no. That is the reverse. That is just the reverse of this Kerala decision.
according to legal opinion. According to legal opinion. Discussing the order. It is director of the establishment.
Yes, my lord. My lord. Well, this is a policy being taken, my lord. Office memo, it was a Ministry of Personal Grievance, Government of India, my lord. My lord, it is, my lord, the office memo has been issued by the Government of India. Under somebody's signature, but it is issued on by the Government of India, my lord.
So that we are like that. Your argument is a policy decision.
My lord.
The retired persons, if they come in the panel also, they will not get the benefit.
My lord. Yes, my lord.
When your argument was advanced, tribunal said, what was the crux of the tribunal? That
My lord, to
delay on your part, or the delay on your part to put the departmental post, the applicants cannot say. And in such discussion, the tribunal placed reliance upon 3 or 4 judges.
My lord.
Wherein the fact issue was that for the delay of DPC, they cannot suffer. Now the matter has been relegated to you.
My lord, one
That has been
difference is also,
relegated to you.
my lord, one difference is also there. There, my lord, there was first of all 12, 14 years of delay, as my lord has find out. Secondly, my lord, the delay was not explained. As my lord will find out from the judgment, the delay was next explained. We have given an explanation. There was 2 and 2.5 years or 3 years of delay, but the delay wasn't been explained by us. This is the difference between those judgment, my lord, and in this case, my lord.
So you pass that order, sir. Has the court said that you give them the benefits? Has the court said? Court has said that you considered their grievance in the light of the judgments of the Supreme Court. And if you find that they are coming within the zone, you
Then
give
give.
them the
Yes,
benefits. Nothing, no, nothing more, nothing less. So why should we interfere?
My lord, because of the difference in this situation, my lord.
So that is left open to you. If you can explain those judgments in your order, problem finishes.
এইটাকে চ্যালেঞ্জ করছি।
না বেরোতে তখনই পারবে যদি ও বলে যে আমার এই ডিসিশনটার এক্সপ্লেনেশন হচ্ছে ABCD ডিসিশন এক্সপ্লেনেশনটা করে দিলাম বলেই আমি মিটার করতে পারবো।
এই জাজমেন্টে মানে এটাকে তো ধরিয়ে বলেই দিয়েছে স্কোয়ারলি অ্যাপ্লিকেবল এবং কনসিডার করতে বলছে
সেটা উনি বললে তো কিছু ইন্টারফিয়ার কখন জুডিশিয়াল রিভিউতে কোর্ট ফ্যাকচুয়াল সিচুয়েশনটা দেখে ফ্যাকচুয়াল সিচুয়েশনটা জাজ করে কোর্ট বলেছে যে এই দুটো জাজমেন্ট order দিয়ে দেবো order pass করে yes, where is your senior? He's still arguing.
Sir,
Who is your senior?
sir, Mr. Appa Chakraborty, the matter was fixed at Honorable Court number 238.
Who is your senior?
Mr. Appa Chakraborty, sir.
Mr. Orpo Chakraborty is arguing, my lord, before Honorable Justice Kaushik Chandra is a fixed matter at 2 p.m. Now, still he is arguing.
এই জয়ন্তকে ডাক দেখো না ডায়েরিতে কি আছে ফরওয়ার্ডার্স এই সুরজিৎ for orders কোনটি কম আছে দাও day after tomorrow. তিন তারিখ কত মিনিট আছে?
No, but
Advocate appearing, heard Mr. Dotto, learned advocate appearing for the petitioners. Today an adjournment has been prayed for on behalf of the respondents. Is the matter as for orders in the daily supplementary list of this court on 9th of August. 10th of বৃহস্পতিবার আমাদের কিছু নেই তো আবার? দশেও আলাদা বেঞ্চ আছে on 10th. You please, Mr. Dotto, you please reconsider this aspect. Your argument is that why should we consider? It is our policy decision. But the tribunal has said, tribunal has not taken away this right from you to reject his case.
No, my lord.
Tribunal has said that in the light of this, we are sitting in judicial review. We cannot go into the factual aspect. Now, when this prima facie, you just check over this issue and come back. Because if he doesn't come on the next day, we will be constrained to proceed in his absence. Yes, next.
Your Lordship, in this matter, I am for the petitioner and Mr. Chakraborty is the representing for the petitioner. And he is presently in Honorable Court number 238, where is a fixed matter 2 p.m. and still arguing. So I'm praying for
2 weeks, yes.
I'm praying for not today, Your Lordship.
Not this week, করে দাও. You are there?
Yes. Item number 18, তোমরা ওইদিকে। Item number 18, I am for the petitioner, ma'am.
Yes.
On the last occasion, the Honorable Court directed my learned friend to take instruction whether they will consider the similar circumstances person who was considered. Kindly come, my lord, the matter, my lord. My lord, kindly come to my lord, the page, my lord, 27 of my writ application, my lord. Of this application, my lord. Page 27, order passed by the tribunal, my lord, on my lord, tribunal, my lord, on my lord, 3rd February 2022, my lord. My lord, operative part, my lord, kindly come to my lord, page, my lord. Page, my lord, 31, operative part, my lord. Quashing the order and remanded back to the matter to the authority concerned, my lord. My lord, that order was communicated, my lord, page, my lord, 33, my lord. But my lord, they have not considered, they have challenged the same before the Honorable High Court, my lord. My lord, the Honorable High Court, my lord, consider the said matter, my lord, page 41, my lord. Page 41, my lord. Operative part, my lord, page 43, my lord. Page 43. My lord,
Their prayer was not considered, my lord. Another 3 months time was given, my lord, to consider the same, my lord. But they have not, again, my lord, not considered. My lord, I filed an application for MA, my lord, application before the tribunal, my lord. Tribunal has said, my lord,
The contempt application.
yes, my lord, MA, application for execution. The learned tribunal has said, my lord, the 3 months time was granted by the honorable court. Your application not entertained because 3 months has not over. So, my lord, again I waited. They have not considered, but thereafter I challenged the same, came before this honorable High Court, my lord. And my lord,
Challenged which order?
the application page 45, my lord.
45.
That period already gone, my lord, because, my lord, the High Court has passed an order, my lord, 21st September 2022. MA was disposed of, my lord. MA was disposed of 13 January 2023. They have not, again, not considered. I filed this application before the Honorable High Court, and Honorable High Court, my lord, several opportunities, given several opportunities. Thereafter, my lord, they file an application, file a compliance report, but they have not considered. The division bench, my lord, directed them to point out the what was the consideration, my lord, because, my lord, the similar circumstances, my lord, another case was considered, my lord.
What you are challenging here?
Here, my lord, shortfall of service. I am shortfall of service.
What is the subject matter of challenge in this petition?
In this petition, my lord, they have not considered my grievance.
Oh, against which order you have come?
My lord, last page, page 45.
45, the tribunal has said that as the time has not expired,
yes, my lord,
I extended with an I dispose of with an expectation that respondents will adhere to the time limit.
They have not considered.
How that can give rise to a cause of action here?
My lord, because, my lord, kindly come to the page 41.
So for that you have to take other appropriate steps, Mr. Mondal.
Page 44, my lord. Page 40.
This 44 Justice Standards order that considered within 3 months.
They have not considered.
That is why you filed an miscellaneous application for implementation of the order.
How many time I go to that, my lord? How many time, my lord?
Subject matter of challenge in the present writ petition. And also you people, why don't you take a decision? You are so busy people.
There was a delay, no doubt, Lord. But
So what happened?
It has been passed. There is an order, Lord, dated 24th May 2023.
24th May 2023.
And copy has been supplied. His case, his prayer for considering the shortfall for qualifying service to enable him to get the pension has been turned down. Now, Lord, since this order has seen the day's light, Lord, subject to your lordship's kind consideration, Lord, he has to approach.
Kindly see the last order passed by the
tribunal, whether this order is the validity of the reasoning of this order has to be tested by the learned tribunal. That is my respectful submission before your lordship, my lord. He did not qualify for pension.
No.
There was a shortfall of more than 6 months.
No, my lord, 3 months, 49 days. Tribunal has category. Sorry, my lord.
On 3rd of February 2022, tribunal squashed which speaking order?
Yes, my lord.
That is, you have retired already.
Yes, my lord. Already. Because
what did you challenge in the first original application? You challenged an order of 5th April 2013 and 13 September 2018.
That application was not annexed. OA application, it was annexed.
That is page 26.
Page Page 26 is the order passed by the tribunal.
Challenging, you challenged which order?
Challenge the order passed by the tribunal on dated
5th April 2013.
13. Yes, that
And
was
there is another order of 13 September 2018.
the similar circumstances. Some of the person challenged the order. That order was annexed because they have also shortfall of service. Because some person 9 months, some person 4 months. That was considered and pension was granted. Similar circumstances. I am not that person. I am qualifying 37 years. 37 years service, but that past service was not counted. So I was 3 months, 24 days. 3 months, only 3 months. But kindly see that.
I am asking you, what is this order of 13 September 2018?
18.
Huh?
Your shortage was of how many months?
3 months, 24 days. Kindly come to the page 31, my lord. Page 31.
3 months, 4 days.
No, 24 days. Kindly come to the page 31.
No, that is not correct, Lord. Our Lord.
We shall come back to
Page 31, last question. As per rule, such and such, my qualifying service, or qualifying service is required, 9 months, 9 years, 9 years, 9 months. I complete, here they have, by short respondent by his false short, 3 months, 24 days, short of 9 years, 9 months. I am working 1983. Sorry.
The challenge. Mr. Mondal, how can we help you? Now the final decision has been taken.
Finally, kindly see the last order passed by this honorable court directed them, leave granted to file a supplementary affidavit, disclosing those person who has granted, those person to mention the similar circumstances person, who has granted the pension, in shortfall of service more than my shortfall of service, I have disclosed, copy was served, kindly see, the 2%, I have mentioned, one, both are come to the court, and pass an order, by this court, and also tribunal, and they have considered and granted pension.
Challenge their decision before the tribunal, saying everything.
That was told, tribunal as well as the division bench, all are considered and passed them, they have.
So how can we interfere with that order sitting in judicial review? That has to be considered by the original forum.
Original forum that was discussed. Kindly see the order passed by the original application.
On 14th May, they have passed another order rejecting your claim.
No, that on that score, the court has directed why you have, without considering those points, the division bench of this honorable court, directed them to consider those points. Kindly see the order.
For that, you have to show these discrepancies before whom you will show.
I go to the again, the court, but how many times they will go, how many times the court has, they have challenged, the tribunal has directed, remanded back the matter. They have challenged the order, before the honorable court. They have continued thereafter, the honorable division bench of this honorable court, they have undertaken to comply the order considering those points, but they have not considered, only for bypass, because thereafter I filed this application. Court has directed why you are not considered, and within time, those they have before the court, and submit, I have already complied only for one vague order.
You have challenged before us the order of the tribunal passed in your MA application.
Not only that, but also the order passed by the division bench.
You are
that is no, their matter. That is not my. If that is my matter, I will file a contempt application, because their matter. Kindly see the matter, they have filed this.
Yes. Tribunal has rejected our coordinate bench has rejected their
claim, and not only rejected, but also give the some order,
Yes.
Kindly see, operative part, page 42, kindly page 42 and 43, operative part 43, they have.
Sir, that is the order passed in their writ petition.
Yes.
You are not understanding a simple question. We are asking you, tell us the answer so that we can help you. Tribunal passed an order in your favor, quashing the initial order and asking them to reconsider. Against that, they preferred an appeal. Appeal was dismissed. Time was extended that you considered in the light of the tribunal's order. Now, when that was not being done, you filed a MA application.
Kindly come to page 43 for a moment, second paragraph, third paragraph. It is further appeared that similar circumstances person has been extended such benefit. Court has clearly stated that point will be considered. That point was not considered. So not a single line.
When they have not considered,
they have copy was not served. Only compliance report filed by this before the court.
What is your remedy now? What is your remedy when they have not considered the order passed by the coordinate bench? What is your remedy? Your remedy is you have to go back to the tribunal challenging this order. They are creating these disturbances. They are wrong. You are right.
Again, 10 years will be go, I will not get anything, Only
we help you, tell us. How
the
can
poor person, came one after another file an application. Court
Where
has
is your order? Where is your order? Have you given copy?
Court ke
file. এটা কি দেব
আজ কোর্টে দিয়েছিল আমাকে তো দেয়নি
আচ্ছা একটা থাকলে দিয়ে একটা কপি দেন একটা থাকলে দিয়ে দিও ওটাকে চ্যালেঞ্জ করবে তো ট্রাইব্যুনালে
আমি দেখে নিয়ে দিচ্ছি আমি দিয়ে দিচ্ছি
This is based on this.
করার নেই তো এইটা লিবার্টি দিয়ে এটা চ্যালেঞ্জ করবে ওকে
হচ্ছে সেটে চ্যালেঞ্জ করতে হবে
সেটা সাইড করতে
সেটা দুটো
অর্থে আপিল তো নয় 26 not an appeal তবে এটা করলে একটা প্রেসিডেন্সি হয়ে যাবে
Where is your supplementary affidavit?
Last action I have filed, my lord. Copy was served, my lord. Last একটু রেকর্ড আছে তো কিন্তু ফাইল করা হয়েছিল হ্যাঁ না ফাইল হয়েছে আপনি ছিলেন না সেদিন ফাইল হয়েছিল আপনার জুনিয়র ছিল
কোথায় সাপ্লিমেন্টারি
আপনার জুনিয়র ছিল আপনি কোথায় বাইরে গেছিলেন
show us any authority that sitting in judicial review we can interfere with that.
Yes, my lord.
Show us an authority.
I bow down, my lord, because my lord,
You have argued well, but how can we help you?
my lord, 1983
We
he is
understand
working,
your-
my lord, without my lord remuneration and regularized were done, my lord, 1990, my lord, retired on 2008, my lord, only for my lord, 1983, my lord, working. They have filed an application for regularization. That was done in 1999, 2008, returned. Only shortfall of service 3 months, 24 days, 9 months. Only that grounds, they file an OA. Thereafter,
Have you considered the supplementary affidavit where he had given instances of 3 other persons?
But after this order, supplementary terms, the order rejecting his claim was dated 24th May 2023,
Yeah.
which I have handed over to your lordship. Now, my lord, everything, Lord, in terms of Rule 88, his case was considered.
No, we are not asking that. We are asking, have you seen the supplementary affidavit?
হ্যাঁ এই তো রিসিভ করে লাস্ট অকেশন কোর্ট আপনাদের বলেছিল যে ইনস্ট্রাকশনটা নিয়ে আসতে যে কেন এই তিনজনকে কনসিডার করেছে একে করবে না
In any case, Lord,
কপি নেই না এটাকে সাপ্লিমেন্টারি
সেম স্ট্যাটাস আছে
সেটা
Take up the supplementary affidavit instances which has been given.
আচ্ছা এই আনিসুর কাকে উদাহরণ দিচ্ছে দেখি আনিসুর
আর সেকেন্ড কেস নাম্বার পর্যন্ত দেওয়া আছে সবার কত বছর তো মেন ওদের যে মেন পিটিশন আমি জিনিস এক্ষুনি দিয়ে দিচ্ছি
কি ওর ওই ছেলেটাকে
yes, Lord, in Rule 88 of the pension rules, Lord, only relaxation clause is there that in case of undue hardship, the concerned authority may consider the shortfall. Now, Lord, in certain cases, definitely certain consideration was made with regard to undue hardship. Lord, he could not be able to show his undue hardship to come within the blood provision of Rule 88 of the pension rule. That is the only relaxation clause.
But that is being decided by Justice Tandon.
Justice, the Honorable Division Bench presided over by Justice. উনি লিখে দিয়ে জানি তো ঝামেলার ব্যাপার। আনডিউ হার্ডশিপের এক্সপ্লানেশন চাচ্ছে একটু দেখি। পেনশন পাচ্ছেন আবার ডিউ আনডিউ হার্ডশিপে, হ্যাঁ পেনশন পাচ্ছেন আবার হোয়াট ইজ ডিউ হার্ডশিপ আনডিউ হার্ডশিপ। My lord, in fact, my lord, I tell your lordship,
Mr. Mondal, you bring it on record, file a supplementary affidavit, bringing the order which you have passed.
Yes.
This 24th May.
Yes.
File a supplementary.
By way of a supplementary affidavit.
Yes, let that come on the record, then we will pass our order. And in the meantime, we'll just go through the supplementary affidavit as to whether it is a question of shortage of 4 months.
That's correct, my lord, but meanwhile.
Consider, Mr. Roy,
Lord,
you have gone a long event.
No, Lord, I understand what has fallen from your lordship. Lord, only thing, Lord, what is troubling, Lord, a batch of SLP.
We will say it will not act as a precedent. Finished.
No, Lord, a batch of SLP was decided by the Honorable Apex Court in 2020. Now, Lord, a lengthy judgment was delivered by the Honorable Supreme Court, consisting of a 3-judge bench. Now, Lord, there, what has happened, Lord, the ministry and the concerned department was directed to decide with regard to individual cases in respect of shortfall. Now, Lord, as per that decision, Lord, the department has taken a decision, Lord, that only Rule 88, the clause of relaxation has to be taken into consideration. Now, Lord, undue hardship has to be explained by the concerned Lord, pension, who is seeking pension, Lord. But here, it supplementary to file করতেই হবে. Lord, আমরা তো অ্যাফিডেভিট ফাইলই করিনি, না কিন্তু ওইটা আনতে গেলে অ্যাফিডেভিট ফাইল করতে হবে।
Reporting form of
Supplementary a copy of the supplementary affidavit filed by Mr. Mondal earlier has been handed over to Mr. Royal and the advocate appearing for the respondents in court today. You given a copy? Yes. Mr. Roy, prays for leave to file a supplementary affidavit.
Report, because this is their petition, Lord. I shall file a report because there is no affidavit. We have filed already, so Lord, supplementary affidavit cannot be. We shall file a report in the form of affidavit. This is their writ petition.
Mr. Royal and the advocate appearing for the respondents prays for leave to file a report. Who will file?
কে ফাইল করবে এটা? কি? Grade 4, Senior Superintendent of Post Office, Midnapur.
The report has you have already taken a decision. You bring that on record by a supplementary affidavit. What will be the problem?
All right. All right.
You are thinking anything else?
No, Lord, I was thinking, Lord, supplementary affidavit, supplementary.
ওটা কি লিখেছো?
In furtherance to affidavit.
Just one. You have given that copy to him.
Yes.
Mr. Roy is directed to hand over. In court today, বলেছো তো? Mr. Roy submits that during pendency of the writ petition,
yes,
A decision has already been taken by the competent authority on 24th May 2022. A copy of the same has been handed over to Mr. Mondal in court today. Stop. চব্বিশ পাঁচ 2023 এটা কি অনেকের ডিসিশন, অনেকের অর্ডার this is an order passed in many cases.
No, Jadab Chandra.
অন্যান্য যে কনসিডার করছে বিভিন্ন আছে, 5টা আছে।
কবে করেছে?
18/8
ছেড়ে দাও, 22/5 করে দিও, 24/5/2023
কমিউনিকেট করতে আন্ডারে কভারিং লেটার ডেটে 24/5 এই যে হচ্ছে
আচ্ছা তাহলে কি লিখেছো?
এইটা পঞ্চায়েত হয়েছে
না যেটা বলছেন 8/5/2023 Stop. Mr. Mondal prays for an accommodation to avail necessary instruction. Stop. Leave the matter as for orders on 10th August. Come back with any judgment that we can interfere.
So I need not file anything, Lord. I need not file anything.
No, if you have given a copy, let him
Yes.
go.
I'm grateful.
Yes, come back with any authority.
Justifying a equal treatment.
Lord, your Lordship has kept it on which date?
10th August.
10th
We
August.
are giving benefit to a person having shortfall of 10 months, but you are not giving benefit to this
Lord, I understand, Lord,
same benefit
Lord,
to the person having shortfall of 4 months.
Lord, I understand, Lord, what has fallen from your Lordship, but I also, Lord, wanted the benefit should be extended to him. Let him approach the cat, Lord. Let him approach the cat.
Cat means again 10 years, Mr. Da.
No. Yes. Let him approach.
Let
If
us
the-
see, we are giving him an opportunity. We had already said that how can you challenge that order before us?
Lord, on the basis of the decision in SLP, batch of SLP, Lord, the department has taken the decision regarding deciding the shortfall issues. Now, Lord, I am handing over a copy to him so that he can.
Mr. Mondal come with an authority that when an order has been passed, whether the High Court in judicial review can interfere when the original forum is the tribunal. You show us that, we will pass order in your favor. Otherwise, it is difficult.
Yes, I am grateful to you.
Lord, in this matter, I am for the respondents.
19, 20, 21, 22, all are analogous matter, my lord. Just now, last week, we have received the opposition from the respondents.
But I am fighting my opposition in all these.
My reply is almost ready. 2 days time is required, my lord. In
2 days.
2 days, almost ready.
Mr. Misro, learned advocate appearing for Union of India. Which are those matters, Mr. Chatterjee?
19, 20, 21, 22.
আচ্ছা শোনো এই কালকে লাস্ট থেকে বেরোবে দেখি না Mr. Misro, learned advocate appearing.
Lord, I am filing my this affidavit in opposition in all the four. And your lordship, the thing is that this is because before your lordships the other bench, your lordship, it was directed because we placed our preliminary objection.
Give one by one. Wait, give one. Yes, Mr. Mishra, what you are arguing? What you are arguing?
This is for the preliminary objection given by us in the for the maintainability of the repetitions.
And reply rejoinder complete in tribunal.
No. We have already given the copy.
So by this. That makes.
Yes. Yes, point has been kept open.
The point has been kept open. You can argue on that.
Yes, but the question is, your lordship, that they are going to give reply to the affidavit on opposition.
We are not to be earlier bench was that order. Point of maintainability kept open, opposition fight.
Yes.
Then what can we do? We will hear at the time of finally.
That is all right, your lordship. When your lordship is pleased to hear, you will be arguing the matter.
By an order passed by a coordinate bench on 5th of June, your statement is recorded that Mr. Mishra takes notice and submits writ petition is not maintainable. And he will file an affidavit to that effect. Next line, learned counsel for the petitioner is argue on the point of maintenance. And respondents are directed. This is a wrong recording. It should be learned counsel for the respondent is entitled to argue on the bench.
Right.
You have filed an opposition.
I'm filing in all. I have already affirmed the affidavit in time and served the copy upon them. The only thing is that filing is before your lordship today.
Mr. Mishra, learned advocate appearing for Union of India, files the affidavit in opposition. Stop. Let the same be kept on record. Stop. A copy of the same has been handed over to Mr. Chatterjee, learned advocate appearing for the petitioner in court today. Stop. He prays for extension of time to file the affidavit in reply. Prays for extension of time to file the affidavit in reply. Let such affidavit reply be filed within a week from date. List the matter in the combined monthly list of August 2023.
वो बोल रहे हैं आपका 2 हो जाना
No, 20 also same order.
Same.
Take the
19, 20, 21,
21, 22 up to 22 the similar matters.
20 ढूकिए दो. Same order.
स्लिप दे दिए सबने My lord has been pleased to fix the matter for.
It will be in the combined monthly list of August.
I'm of the list.
Hey, John. Take it out. Make the
The very next matter, my lord, there was an interim order, my lord, till 19th of July. I have mentioned this matter, but the matter could not be listed, my lord. My lord, in this matter, my lord, item number 23.
Tomorrow
So
this
at
will
least
be
my lord,
heard.
also kindly extend the interim orders and fix the matter, my lord.
When is the interim order expired?
On 19th of July, I have mentioned twice, my lord, before the bench having determination. But my lord, the file could not be tested.
Tomorrow, perhaps this matter will be heard.
But my lord, this
23.
interim order, my lord,
No affidavits have been exchanged.
no,
Then you won't file any opposition?
no, my lord, no.
Check it up and come tomorrow and tell
My
us.
lord.